Not tied up matter. Regular matter. Seriously ill, mother seriously intellectual matter.
Last week, my lord has
matter in this book.
last week, my lord has specifically directed to list this matter this week, but it has not been listed.
Yes. देखिए वो कोड कौन है? Memorandum देखिए. Yes.
I beg your pardon. Pardon to mention, my lord.
Yes.
Tied up matter.
My lord, this is tied up matter BAPL number 2517 of 2024. Last week I also mentioned the same matter, and I also filed mentioning memo. My lord had directed to list this matter this week, but it is not listed today, my lord. Kindly list this either tomorrow or day after
Did
tomorrow.
you file a mention memo?
Yes, my lord. I have filed last week.
What is the number?
2517 of 2024, my lord.
All right.
Alright.
And may I please, my lord, here the BLAPL was filed in the month of November 2023. I have filed mentioning memo for 3 times. Unfortunately, this matter is not listed, my lord.
Yes, it will come.
My lord, one tied up matter.
Yeah.
I beg your pardon, my lord.
Yes.
BLAPL
I would like to submit this
13274 by 2023, my lord. I have filed several memos after your advice, my lord, but it is yet to be listed. My humble prayer is let me
I will
kindly.
file another memo and see. Yes.
Okay,
So Beroda को mention तो ये तो मैं इसको weekly list में इसको है ना?
May I please your lordship?
Yes.
The case matter which your lordship has had in respect of the co-working persons and granted bail to them. That is a transplanter machine. They should have obtained it from the original owner from Bangalore Box
I'm
Superior.
taking up the weekly daily matter. I'm taking up the weekly daily list.
Sorry.
Your item is probably item 1 of the weekly list.
I'm sorry. So sorry, my lord.
All right.
They have not followed the list. I'm sorry, my lord.
It's all.
May please your lordship.
Yes.
Item 1.
Yes.
CRPC, your
Yes.
lordship. The petitioner husband has filed the transfer petition for transfer of CP number 61 of 2022 from the learned family judge Cuttack to learned family judge Jajpur, your lordship.
Why? What ground?
The CP 61 was instituted by the petitioner husband for seeking a decree of divorce, your lordship. While the matter stood thus, the opposite party wife has instituted 2 cases at Jajpur.
Yes.
So for convenience of both the party, the petitioner husband wants to transfer the divorce petition to family judge Jajpur.
The other two proceedings are at Jajpur.
Yes, your lordship.
Where is it?
The CP number 33 of 2022 is filed under section 9 of the Hindu Marriage Act, your lordship.
And this is section 12 of the PWDB Act.
Yes, your lordship. That is pending before the SDJM Jajpur, and the transfer section 9 petition
Alright.
for restitution is pending for the family judge Jajpur.
Transfer of CP number 61 of 2022 filed by the petitioner in the court of learned judge family court Cuttack is sought to be transferred to the court of learned judge family court Jajpur, mainly on the ground that 2 other proceedings instituted by the opposite party wife are pending before different courts at Jajpur. So issue notice to the opposite party by speed post, fixing a short returnable date. The requisites be filed by tomorrow. List this matter on
6th May.
Huh?
6th May.
6th May. All right, 6th May. So speed post like 6th May. 29th April. Further proceedings in you prayed for 3 proceedings, stay of 3 proceedings
Yes, your lordship.
in one petition. How?
Maybe pardon your lordship.
How?
The
The only stay can be granted only in respect of the proceeding in which you seek transfer, of which you seek transfer. The other proceedings cannot be stayed.
then your lordship, my humble submission is an observation maybe.
Notice as above. It is open. It shall be open to the petitioner to move application for adjournment of the case in the court below, which shall be considered having regard to the date fixed for hearing of this case. Yes.
Much obliged.
I do not to May it please my lords, the petitioner wife has instructed the transfer petition to transfer a CP proceeding initiated by the husband opposite party my lords under section 13(1) the Hindu Marriage Act for dissolution of marriage my lords. The transfer from the judge it is pending before the judge family court Jagat Singhpur my lords. So it should be transferred for judge family court Cuttack my lords. It's a prayer of the petitioner.
On what
The
ground?
petitioner now is my lord studying in one of the competitive courses. Your lordship may kindly glance at annexure 3, your lordship. Currently studying at Cuttack my lords and preparing for a competitive exam my lords.
All right, issue notice to the opposite party by speed post fixing a short returnable date. Requisites be filed by tomorrow. List this matter on 29th April.
I have stay my lords.
Further proceedings in CP number 84 of 2021 in the Court of Learned Judge, Family Court, Jagat shall remain stayed till the next date.
Item number 3, my lords, it is between the same parties. Here the petitioner wants to transfer the proceeding under section 9, which has been filed by her, my lords.
Same
Just-
order. Same order.
Item number 4. Much obliged.
The wife has filed this application for transfer of CP number 736 of 23, a proceeding under section 13 of Hindu Marriage Act from the learned judge Bhubaneswar to Jajpur.
Yes.
From Bhubaneswar to Jajpur, because that in Jajpur, my lord, 2 cases of at the instance of the petitioner are pending. The lords will get at page 24, annexure 2, the proceeding under section 125.
All right, issue notice. The opposite party by speed post fixing a short returnable date. Requisites be filed by tomorrow. List this matter on 29th April. Further proceedings in CS number.
मतलब CP भूल गए
अपन CS लिखते थे.
टाइप
Agalakund, the learned counsel of the petitioner is permitted to correct the typographical error in the prayer portion of the application in court. Further proceedings in CP number 736 of 2023. Pending in the Court of Learned Judge, Family Court 1.
Yes.
Bhubaneswar shall remain stayed till the next day. Correct it.
Yes.
Item number 5.
Item 5, pass over.
Item number 6.
Pass over.
Item number 7. Pass over.
Pass over.
Item number 8.
Item 8. Pass over.
Item number 9. Should I pray for a passover? Mr. DM Ratitan Lex.
All right, pass over.
Item number 10.
I am in virtual mode, my lord.
Yes.
I am for the petitioner, my lord. My lord,
Yes.
my lord, there are 2 cases in the list. One is, my lord, WPC 14109 of 2010. That is listed as the main case. And along with that, another writ, my lord, that is WPC number 6732 of 2016.
Yes.
These 2 cases have to be taken up together because petitioner is the same, only cause of action different and opposite parties are the same.
Yes.
But here, what has happened, my lord?
The pleadings are complete.
My lord,
Yes.
yes, pleadings are
Who's for the other side? Yes.
I am in the second matter.
Second matter, in the second matter, you are for the opposite party.
I'm for the opposite party.
Who's for the opposite party in the first case?
Mr. Rautra. Yeah.
Yes, his associate is here. All right. Yes, sir.
Yes, my lord, here what has happened, my lord? My lord, I have today given to your lordships, my lord, notes in both the cases. Lordship may kindly take up the notes in the first case, my lord.
Yes.
That is a date chart. Date chart. Some dates are common because here the first case is, my lord, that the institute who has become now an university, my lord, they denied the benefits of 6th pay commission to the petitioner with effect from January 2006, though 5th pay commission's benefit were extended to her. So therefore, I have filed this writ application for grant of sixth pay commission benefit and revised salary accordingly.
Yes.
While this matter was pending, an interim order was passed by your lordships in this case that no coercive action will be taken against the petitioner. But despite that, my lord, they have forcibly terminated the services of the petitioner with effect from 31st March 2016, forcibly, without any inquiry, without any notice, my lord, by throw of her baggages from the room, and my lord, that is why I have filed the second writ, which terminated my service without any inquiry, though she is a confirmed employee out of grudge and malice. So these two writs, your lordships, may bear in mind.
Yes.
This is the only difference, my
No,
lord.
but if there was an interim order protecting you, well, you could have also filed a contempt apart from challenging the order of termination.
Contempt has been filed, my lord. Contempt has been filed. It has not been listed. Perhaps it will come separately, or I do not know. I have filed a contempt, my lord.
No, we'll call for the contempt anyway. Let us hear. What is this matter, basically? You are not
Yes.
completing it today. Let us hear.
Yes, my lord, lords may see the first date chart in the first note, my lord.
Yes.
First writ, my lord, 14109 of 2010.
Yes.
Lords have got it. My lord, I am just quickly placing the prayer in the present writ petition is to direct the opposite parties to pay revised salary to the petitioner as per sixth pay commission recommendation with effect from January 2006 till date. Then, my lord, 17 to 89, that is annexure 3, petitioner being selected in interview, joined in the post of research assistant on 20 to 89 in Xavier Institute of Management, Bhubaneswar.
Sir, may I just ask you to pause for a moment? If your writ application is against Xavier Institute of Management, how will it be maintainable?
No, it has now become an university. From 2013, by an act of the state government, it has become an university. So, my lord, will your lordship say that a writ against an educational institution and that to an university will not be maintainable? My lord,
No, it
nowadays?
became a university only recently, and it is known as XIM University.
My lord?
And in fact, I was the law secretary when it became. So I'm quite aware of the facts. But it is again, when you filed, it was a private institution, pure and simple. Now it may have become a university, but long after it was, in fact,
I will argue with fast, my lords, to see whether it's maintainable.
No, let me finish.
Yes, certainly. I'm just raising this question for you to be able to assess the court better.
Yes, my lord, I know there is a judgment, division bench judgment of this honorable court, which has said that the writ against Jim is not maintainable. But that will be, according to me, my lord, with great respect, that is judgment per inquirium. My lord, your lordships must have seen, my lord, number of cases of the Supreme Court, which they simply say that if an educational institution is discharging public duty, then it is amenable to Article 226.
Provided a public law element is involved. A very recent decision of the Supreme Court in St. Mary's, I think 2023, Justice Padriwala's judgment.
I have given
myself dealt with such a similar, I have myself dealt with a similar issue in Christ College, where I've held that it being a minority managed institution, writ application, it will not be amenable to jurisdiction of this court. More so, as a public law element is not involved. It was a question of contract of personal service. So enforcing a contract of personal service through a writ application may not lie. So I would like you to address the court on the maintainability aspect first.
Yes, kindly see the notes of case laws I have given today. It's a bunch
Sorry.
That's all right. Sir, have you filed anything today, sir?
Yes.
आज दिल्ली लिखे कौन आज कौन फाइल
Out of notes of judgment in both the cases.
One thing I point out to us is,
Yes.
so far the maintainability is concerned.
ऐसे कोई पर
No, sir, that exactly that. This particular matter. Yes, sir, maintainability, I have a right to address first because of maintainability. Sir, one thing I will point out to us, this matter along with a batch of writ applications directed to be listed by virtue of a judicial order, by virtue of this amendment. So the matter was listed time and again to hard time and again, the batch of cases. But somehow the other batch, which are connected with this, the other batch that was disconnected and was listed with a privileged batch. That matter was hard. I was the counsel appearing for the Java Institute, and Mr. Patta, Jagannath Patta was appearing for the petition. And after hearing at length, a coordinate bench pronounced the judgment in the open court that it is not maintainable. Those cases, a batch of cases, number I have got, all these points with regard to the maintainability was raised, and it was held that it is not maintainable. But that judgment, copy of the judgment has not been uploaded. I tried my best in the morning to not been uploaded. If your worship will call for those files, your worship will find that all these points have been dealt with in those cases. So
this is the same matter.
no. That was the lead case. The other cases were also
762 of 2000.
So that's cases. Kindly come to next page. WPC 7095, 7096, 76732.
So you mean to say the judgment passed in the batch of
direct hearing so far this case is concerned.
so we'll call for?
Yes,
Let's call for.
Millard, with great respect, Millard, the difference between those cases and this case is that, Millard, here the termination is after it became an university. 2013 it became a university, and she was considered as a member of the university as a staff of the, and her services terminated.
Yeah, there also the question with regard
2013 it did not become a university.
sir, that was also been taken note of in that judgment. That was experienced.
2010
Referring to any judgment, including the matter with regard to the statute, it is not taken over. It has become a statutory university in the year 2013. That is the difference.
Okay.
Millard, this is, Millard, the opposite parties have always tried to, Millard, curb this case.
No, sir. I will hear you. But one thing, let us call for that case record to see for whatever it is.
That's it.
You can make your own arguments, sir. You can make your arguments independently. So let it come. If the judgment has been passed, and I find from the list that this was all earlier listed along with those applications. If a judgment has been passed in those cases and it may have a bearing on this case, let us see it. Let us see it for whatever it is worth.
Lordship may see it, there is no difficulty.
I'll call it tomorrow. What do you say?
No.
And mainly first let us decide. If you say that judgment was passed in Curiam, it is possible. This court can also ignore it. If it was
Yes.
This court can always ignore it.
Because I couldn't able to also to look to the entire judgment because only it was pronounced in the open court that is not maintainable. But the judgment I could not able to find out because it has not been uploaded.
Anyway,
So may I request your worship,
yes, sir.
Millard, in this 21st century, in view of the large number of decisions of the Supreme Court, right from 69 Supreme Court onwards, Millard, can it be said an institution imparting education, Millard, is getting aid from the government, land from the government,
No.
everything, and it is not maintainable, Millard. And governor is one of the visiting.
No, sir, I think that has been answered by the Supreme Court recently in that Justice Pardewala's judgment. In Mary's
So that judgment and that judgment has been taken note of by the coordinate bench.
yes.
Millard, Supreme Court in
And
Charles Collins case.
that was against
I have also gone through that judgment.
That was against
judgment judgment has been placed before the honorable coordinate bench. That has been taken note of. So sorry, Mr. Pat. Yes.
Millard, your Lordship knows in G telefilm case, the Supreme Court said that even if somebody is not an authority, but Article 226 is always available.
always there, provided it is qualified by the requirement that a public law element must be involved.
Yes.
It cannot be utilized to enforce a contract of personal service. This is my only thing.
That's it.
This is whether this comes within the ambit of that rider or not. This is to be seen. So what I will do is I will just call for. So whatever judgment has been passed, this court let us go through it. Let us go through and see whether it has a bearing on this. I will call it tomorrow. I'll call it
नहीं सर tomorrow ठीक है मेरे को बैच मैटर अच्छी भाई दिस मैटर
the day after tomorrow.
मैं को छुट्टी है गुरुवार की
Next working day कौन? नहीं, day after tomorrow छुट्टी नहीं. Day after tomorrow छुट्टी नहीं.
नहीं बुधवार छुट्टी so well there is one difficulty since this is a very vulnerable worship will be considering in the writ petition normally we make a declaration that why the opposite how in what circumstances the respondents come within the ambit of the jurisdiction. There was some declaration given in this, but only thing is said, I'm a university employee.
But that will not stop the court from posing this question. In the High College matter also, what Mr. Khangari is saying, in the High College matter also, it was never pleaded.
I want that. I'm with the court millers. Some documents I would like to bring to the. It's easier for us to look at this. Monday to coming Monday.
So,
Next week.
this is a miscellaneous bench. This is a miscellaneous bench. Sometimes bail, sometimes transfer, sometimes civil. Whatever.
We have not seen that for a long time to Mr. Pranay. Request Mr. Pranay to come here at least. We can have some interaction.
No, I can see you. I can see you.
I'll go to your house.
Sir, but your physical presence will be more helpful. I think that is what Mr. Raita is saying.
I am not assuming as you.
I think either Kuku matter or Ashoka release. It is submitted that it is submitted by Sri Buddhadev Rautra and senior counsel appearing for the opposite party that this matter was originally listed along with a batch of writ applications.
Number
7395.
And judgment has been pronounced in respect of some of the writ applications. Stop. Since the judgment passed in the said cases may have a bearing on the outcome of this case, he prays that the case records of the said cases be called for proper appreciation of facts. List this matter. Sir, we'll call it on Monday, next Monday.
All right, Milord, may I pray, will your lordships direct the office to give us a copy on payment of charges of the
Payment of
Yes.
judgment, though? Yes. List this matter on 15th April. Stop. It is stated at the bar that the copy of the judgment passed in the batches in the said batch of cases has not been uploaded. Stop. Since both parties would be relying upon the judgment, the said judgment, office is directed to supply copies of the same to the counsel appearing for both parties in this case. That's
Okay, thank you.
yeah.
So your lordship is calling on Monday.
Monday, 15th. Yes.
All right.
Item number 11. Item 11. Vidam Patna पे चली हुई और मेरे पास और कोई की पास और सब देखिए. Item 12.
I think my learned friend is appearing for opposite party number 7. And last time he probably has filed a counter.
Private opposite party.
Yes, my lord, private opposite party.
Filed an affidavit. You filed an affidavit. Yes, my lord. I filed an affidavit on 9/1/2024.
The but that no copy has been served on us, sir.
Your opposite party number 7, my lord. Additional affidavit filed on behalf of opposite. Why do you call it additional affidavit? Had you filed an affidavit earlier?
No, earlier it's not filed.
But you call it additional affidavit?
I said direction.
No, it is written here additional affidavit.
Yes, sir. Additional affidavit filed with the state.
No, state has filed. They have also, I mean, it is my affidavit says only affidavit, your lordship. States affidavit is an additional affidavit. My lord. Well, there is an additional affidavit. Additional affidavit filed on the both the the date is not visible from January 2024. Probably you filed it recently. What about the other affidavit? Do you have a copy filed by the state? Nikhil?
That is also additional affidavit filed. So that gives us the impression primarily an affidavit of the file.
Nikhil, hard copy tell.
ଲେଖା ହେଇଛି କିନ୍ତୁ
ଆମେ ପଢିଲା ବେଳେ ସାର୍ ଆମେ confuse ହେଇଯାଉଛୁ କାହିଁକି ନା ଆଡିସନାଲ ୱାର୍ଡ ଚାଲିଛି ମାନେ ଗୋଟେ affidavit ଫାଇଲ ହେଇଛି
ତାଙ୍କର ବି ଦେଖେଇ ଆପଣ you filed it in 2024, my lord, in the month of January. You have mentioned it as a affidavit only. No, my lord, additional affidavit. ସେ ତ ମୁଁ କହୁଛି index ରେ affidavit ଭିତରେ addition. Index page ରେ କୋର୍ଟ ଫି ଲଗେଇକି ଆମେ ପାଣି ମରିକି ତାକୁ ଛଡେଇଛୁ ଜାଣିଛନ୍ତି? So you have the pleadings are complete then.
No, sir, I have not received the affidavit.
Why don't you give a copy? Copy has been served, my lord. I'll serve another copy, my lord. A good way of taking adjournment, isn't it? My lord, I have actually served the. If you filed it in 2024 and you know who the opposite party is, you will not file.
I am for the petitioner, sir.
You are for the petitioner, yes. Let a copy of the additional affidavit filed on behalf of the opposite party number 7 be served upon learned counsel appearing for the petitioner by tomorrow. Let's this matter next week. Next week, okay? Monday? Next Monday?
ଗୋଟେ ଜାନ ମୁଁ ତ ଫେର ଇନଷ୍ଟ୍ରକ୍ସନ ଦେବି ନା ସାର୍ affidavit ରେ
22nd.
yes
Item 13, pass over.
item number 14
In this case, I'm challenging next 3 and 4 now. My lord, this is that matter, my lord. On the last occasion, over telephone, my lord, I got the instruction that the CDPO who joined recently could not treasure the file, and she was not in a position to produce the file for lordship. So lordship had specifically directed to file an affidavit by 4th by the then CDPO.
She has filed an affidavit.
My lord, but the affidavit has been filed by the present CDPO.
No,
My lord, the then CDPO was there. My lord, she got the promotion. Thereafter, my lord, she retired in the meantime. So the present CDPO, on the basis of the facts available in the records, my lord, she has submitted the affidavit saying that the previous CDPO, she had visited the office of the Advocate General immediately after receiving the order from the Honorable Court, but finding the same to be insufficient, she was directed to produce the file. There are 2 documents, my lord, which were directed to be produced. One is with respect to selection of Anganwadi worker, and one is with respect to selection of Anganwadi supervisor. Because she got the benefit of appointment to the post of Anganwadi worker on the basis that she was previously working as the Anganwadi supervisor, organizer or helper, my lord. That is the reason. So there were 2 documents which are required to be produced. Even though, my lord, the first document could be trusted, my lord, but the second document could not be. So thereafter, my lord, before any further date could be, the case could be posted for further date, my lord, the then CDPO, she got the promotion and being relieved, my lord, she joined at Noyagot, and thereafter she retired from service. And in the meantime, the BDO, he remained in charge of that particular post, and thereafter this deponent, in the month of August 2023, my lord, she joined there. And with her best effort, my lord, on the last occasion, she intimated me over me, my lord, intimated me over telephone with respect to the difficulty to trace the file. But now with all effort, my lord, now the file could be traced. And once again, my lord, the selection file with respect to the Anganwadi worker, that is very much available. And so far the Anganwadi helper or organizer, my lord, the relevant documents which establishes the engagement of that particular person is there, but selection file is not available. That is what she has mentioned in the affidavit. And today I have all the registers and the files, everything is available with me.
How do you decide this matter? In the absence of that relevant. Just recapitulate the facts. What happened? Let's see. Let me first go through the previous order. Yes. Call for the original file related to engagement of Anganwadi worker related to Anganwadi center. So that is available. That original file relating to engagement of Anganwadi worker of Lehadi 2, that is available. All right. And we to appointment of petitioner as Anganwadi helper of the same center. That is not available.
That is, but yes, madam. The ADM, while deciding the appeal, has categorically reached to a conclusion that the CDP office could not present the file relating to Anganwadi supervisor or Anganwadi helper because she got the benefit of appointment to the post of the Anganwadi worker on the strength that she was previously engaged as the Anganwadi helper. So that is why your lordship wanted to see both the files.
So what is the affidavit file here? Let us see.
There are documents to the effect, my lord, the CDPO, the then CDPO had issued the experience certificate on the basis of the different registers. The duties assigned to the Anganwadi helpers, my lord, to receive the food materials and to distribute the same among the beneficiaries. Those documents are there, those registers are there, the minute books are there also, my lord. But there is the selection file with respect to engaging that
Initial engagement as that helper or organizer, whatever you call it.
available. And that is the reason for which, my lord.
Let's an order first about this.
Yes. I think, my lord, the affidavit is very.
An affidavit has been filed
Affidavit
by
is not filed.
Srimati Manorama Mishra, presently working as CDPO Ulunda. Stop. It is stated therein that her predecessor, Jayanti Swai, CDPO Jayanti Swai had come to the office of the Advocate General at the relevant time, but the documents being found to be inadequate, she was asked to bring the entire file. However, in the meantime, she was promoted as DSWO and transferred to Nayagarh. Subsequently, she has superannuated from service. Subsequently, it is submitted by Sri S.N. Patnaik Learned AGA, she has superannuated from service. Be that as it may, the original file relating to selection of Anganwadi worker of Lehadi to Anganwadi Center, including and other documents such as proceeding register, etc., have been are available, have been produced. Stop. Insofar as the file relating to selection of the original selection of the petitioner as Anganwadi helper is not available, as it could not be traced out despite several efforts. Stop. The deponent has begged unconditional apology. Stop. Unconditional apology for not producing the original file earlier. Stop. Since the original file relating to engagement of Anganwadi worker of the concerned center is available, hearing of the matter is taken up. Yes. What is the matter? Yes, Mr. Naik.
Yes, my lordship, I am working in this.
You are challenging the order
3 and 4, my lord.
ADM's order.
ADM and sub collector. Lordship, I
What are the facts?
pardon.
Facts.
Yes, I am working in this organization, my lord, last 24 years. And first as organizer and then helper.
Organizer and helper are different.
Yes. first organizer, then helper. In the year of 2000, honorary 20 rupees John did organizer. And in the year of 2009 and 2005, my lord, I was engaged page 23. My lord.
Yes.
Certificate has been supplied to the petitioner. Then what's at page 25? At page 25, I was engaged as helper. My lord. सहकार्य पदवी अस्थायी भाव नियुक्त कराला आदेश 7 दिन एंड यही पदवी सरकारी चाकरी पदवी सरकार द्वारा निर्धारित मासिक 750 टंका हार सम्मानजनक ऑनर व्यवस्था रही संतोषजनक भाव में कार्य संपादन करते पर्यंत एक रही एंड नेक्स्ट पेज दिस इज द बॉटम माय सिग्नेचर एंड आई हैव वर्कड and I've just instances that rest of 2 pages I've given and bunch of documents with me that which shows that I'm working since 2009 and page 28 my lord, I was also undertaken as given the training. It is project has undergone job refresher course of Anganwadi workers organized 28/2/2013 to 31/3/2013. And then my lord, the page 29, the advertisement comes from for Anganwadi lady 2 Anganwadi worker. The first serial number 1 my lord, lady 2. And it is specifically mentioned 15/2/2010 पर कौन सी दरखास्त ग्रहण करा जिवो नाही एंड नेक्स्ट मिनट द पेज 31 क्लॉज 4 अंगनवाड़ी केंद्र रे सहायकारिणी किंबा संगठिका क्षेत्र रे आवश्यक शिक्षा योग्यता थिले एवं तांकर 5 वर्ष अधिक अभिज्ञता थिले तांकर कार्यक्षेत्र विचार को नै अंगनवाड़ी कर्मी भाव रे मनोनयन करा जाई परिबो बेसिंग अपॉन दिस I have applied and I was engaged. And
As helper, Anganwadi worker.
yes,
Then what?
while I was engaged, the OP number 6, there were 3 candidates for her. I was on the serial number 1 and another Professor Panigirai on the number 2 and OP number 6 is the number 3.
What is your name?
Mediation Panigirai.
Mediation.
And the OP number 6 filed one writ application before the Honorable Court in the year of 2011. And to consider the reprehension by 3 months, that was the order. And then she approached the suppletor. Suppletor approached and the suppletor filed the answer 4 million.
Answer 3.
Answer 4 million.
Yes.
This is page 43.
Yes.
Answer 4, page 43.
What is Annexure 3?
This is thereafter in the year of 2015 that another appeal law. This is the
So what happened to this order?
yes,
What was the order passed?
yes, no. It's 43. This case arisen in obedience of the order.
No, sorry, main portion of 44. That the selection committee did not add the mark of physical disability certificate.
If it's 43, accordingly, both party present and the appellant noticed the both party present and the appellant Kuni Mahapatra, the OP number 6 stated there, she had submitted all the relevant documents. And the application to the post of Anganwadi worker lady 2 on the page that but the CDPO Ulunda did not produce the disability certificate before the selection committee, for which the mark to be awarded for physically disability certificate was not added in the merit list. Within the due time, she didn't file. CDPO Ulunda has submitted admitted that the mark of physical disability certificate has not been added in the favor of OP number 6. And after hearing both the parties, perusal of the documents, I am of the opinion the selection committee did not add the mark of the physical disability certificate in favor of Puni Mahapatra. Issue direction to the CDMP Ulunda. That's the first order. And let's say if at that point I am not there, and within the due time, the disability certificate was not filed. And as per the advertisement as earlier,
So what happened? What happened after this order?
then nothing. Then this is in the year of 2011. Lordship in the year of 2014, another writ application was filed by OP number 6. Again, order was passed. The petition, the grievance will be considered by the ADM. ADM passed this order. And till that,
Order under Annex 3.
3 million. Till that, and till passing of
What did the
yes, ma'am. It was 33 million.
33 आरंभ होछ.
Yes, ma'am. And my lordship,
39.
it is 42. Sorry,
39.
$38 and $39.
Hold on.
38. Which Anganwadi helper and organization helping requisite how that to be the shall be selected as Anganwadi worker for the 5 years.
So now the issue is
Now the issue is to actually, and the Hagasini worked as an organizer for more than 5 years or not. The veracity of the certificate issued by the CDP Ulunda in favor of the selected editor of Hagasini Panigai. The emotion
decision as to why there was advertisement for me with the balance on on verification of accordance register at CDP office, it was found that Srimati Mundija Puruch was issued under forms. So he holds your selection as illegal, isn't it? That you have been illegally selected. Yes, that's all. You have to show how is it wrong.
but entire so sir, I am absent. I have not been noticed.
You have not been noticed.
Yes, ma'am. And that's in the specific averments I have taken. And
The advocate on behalf of the appellant is present. The GP is also appellant is key.
appellant OP number 6, bro.
Okay.
And my submission is not there, and I have not been noticed. The fair opportunity should be given.
Yes, Mr. Patnaik.
Yes.
My note. You have the file.
Yes, ma'am.
You have the LCR.
I don't think so, but because already, yes, my lord.
Your notice has not.
The ADM came to a conclusion at the appellate authority that the CDP office would not produce any relevant document with respect to initial involvement of the petitioner as the Anganwadi organizer or helper.
So that is the reason, because there is a specific clause at clause number 4 of that revised guideline of 2007, that in case any Anganwadi helper is there with 5 years of experience, then in that case, she is to be selected subject to other condition by that she is otherwise eligible to hold that particular post. So that is the basis on which the selection committee found that this petitioner is eligible. And they had utilized the documents, the experience certificate issued in favor of the petitioner minor. Now, such documents were also taken into consideration by the ADM. But he came to a conclusion that since the original selection file would not be produced, that is why I smell something fishy in this case, and then accordingly, the selection committee has not committed selection in a proper manner. After going through the different documents, my lord, this cannot be exactly said that it is correct, but they are saying that there are some Grama Sabhas, and in that Grama Sabha they used to select some persons as the Anganwadi organizers, and on that basis they used to receive the food grains and other materials, and they used to put their signatures in the different registers. They receive the
photos. Going to the merits. My question is plain and simple. If this order, this is an order adversely affecting the petitioner.
Whether notice has been
issued on that ground alone, it will go. Yes. This notice has not been issued. Yeah, this has a full bearing on his on her livelihood. But if notice has been served, then I'll go to the merits.
Anganwadi selection file touch.
You don't have the LCR?
I think so.
LCR where have you taken that plea?
Yes,
repetition.
My lordship, that's plea. He has no comment. He has mentioned in the affidavit.
Where is that? In which paragraph you have said?
Paragraph 13.
Paragraph 13 of your writ application.
Yes.
Yes, specifically said that he has not been noticed in the said appeal.
And in the counter, my lordship, I have a glance that the answer has been, there is no comment.
No, the counter must have said that they were noticed.
No, they
have said, they have got the copy.
That can be verified from the file.
Yes, yes. Counter, what is stated, should have been verified.
Can be verified. Yes, Mr. Patnaik?
May I just permission of the court?
I'll get a specification.
No, Mr. Das, I will hear you. That's doesn't matter. But you will also agree that if the petitioner has not been heard, has not been noticed, then how can this order be maintained?
With permission of the court, I will just say 3 lines.
Yes.
My lord, his client was selected. I challenged that selection in first writ. It was directed for consideration. On consideration, the benefit of physical disability certificate was not extended. It was extended. I was selected. My lord, now, my lord, they are before the writ court. Writ court is a court of equity. If he is not otherwise qualified to hold the post, whether the writ court to grant the relief, that is for consideration of your honorable court. One thing. My lord, I have secured highest mark. 3 persons were there. One has left. Is not interested, somehow other engaged. Now contest is between the 2, and I have got the more marks. So the honorable court is a court of equity. My lord, if otherwise he is not entitled, my lord, whether this writ court would grant, apart from the fact that in the counter that so what happened, my lord? When the benefit was granted, that was not when the order in the first writ was not implemented. So I filed another writ. In essence, raising a grievance that order could not be implemented. That the honorable court in the second writ said that that is to be looked into. That was treated as representation on appeal by the ADM. Annexure 3 has been passed. My lord, in the Annexure 3, my lord, page 39, your lordship may kindly see. Whether he has come with clean hands, page 39, your lordship other day had seen. Then I will address your lordship on the notice aspect. Yes, that 39. 39.
Is that it was found that Sumati has issued honorarium for 4 months at the rate of 20 for the period of.
Last para, the in course of the visit, your lordship may kindly see.
You are reading from page 39.
For it up. Page 40.
In course of visit.
Yes, page 39. The way Srimati, my lords have got my lord. Page 30. The way Srimati Bhagyasini Panigrahi was selected as Anganwadi worker of lady 2, anyone can smell a rat in the absence of relevant paper document to establish that she has worked as an Anganwadi worker continuously for more than 5 years. Non-submission and non-availability of office copy of certificate issued and the photocopy of the certificate cast doubt on the veracity of the certificates. The photocopy of the certificates, if actually issued, had a procedural irregularity with no copy available in the office, that no from the all the things entire, my lord. There was no document, there was visit, nothing was found out, my lord. Apart from the law, the other day I addressed your lordship on facts and on law. My lord said on facts, let us see what the order is purpose or other thing. Facts relating to the fact that there was visit, no document was available.
But Mr. Das, the question is whatever may have been the finding probably this court may not touch because it's a factual finding. The writ court will be very, very slow to enter into that.
Yes.
But can any order, adverse order be passed against a party without hearing?
Not hearing, but one thing your lordship can.
This has not been.
It's a possible defense.
That will not be considered.
Right, I bow down.
I know you are raising the doctrine of empty formality. This cannot be declared as empty formality.
Bow down. So, good I will just say, your lordship may kind see on the law, my lord, by learned friend is relying on clause 4. Advertisement is published. Purpose of advertisement to invite application. Those who would feel themselves qualified, they would be applying.
That's all right. That's all right.
Can it be considered in isolation?
Rightly or wrongly, Mr. Das, she was engaged. Rightly or wrongly. I am not passing any judgment on that. But the thing is that if the principles of audi alteram partem have not been followed, then this order will go. As simple as that. Without any.
The counter a commission in notice says
Paragraph 9 of the counter. Paragraph 9 of the counter.
You are opposite party number 4.
6.
That as regards the averments made in paragraph 13 of the regulations, this deponent has no comments to offer.
Para 8.
Para 9 bro.
8
Page 5.
ଆପଣ ସେଠି କେତେରେ କହିଥିଲେ?
ଆମେ para 13 ରେ କହିଛୁ ଯେ no notice and he said that there are no comment.
But in para number 8 of the counter.
Yes, it could not be produced by us. So in absence of these vital documentary evidence, under ADM has. Well, this court will simply ask you to find out whether notice was issued to her.
To that extent, my lord, paragraph number 8.
8 of the.
So there is a clear ruling.
No, 8 I'm going to
In this said appeal question. In this said appeal, both the parties are
You have not specifically denied.
But we have also not indicated.
Her averment you have not specifically denied.
Yes.
So this goes to the root of the matter. You produce the.
I will produce.
Produce the that appeal file.
Yes, the file is the notice
In course of hearing.
That is
It is submitted. It is submitted by land counsel to the petitioner that the notice of hearing of the appeal was never issued to her, never issued to the petitioner. So she has specifically taken such stand in her writ applications under paragraph
Paragraph 13.
Paragraph 13. Stop. The state has not specifically denied or disputed such averment in the counter filed by it. Stop. This court would like to know whether notice was actually issued to the petitioner by the ADM. Whether DGA shall inform the court accordingly, and if necessary, by producing the file in Anganwadi appeal number.
It was 2015, sir.
In AWW case number 2 of 2015 of ADM. ADM Suvarnapur. List this matter. I'll get to 2 weeks time, not further than that.
Yes.
This is matter on 29th April.
My lord, actually, I am sorry, my lord. With respect to that paragraph number 8, that is with respect to the appeal number 2 of 2011. There was previously another appeal. So there, my lord, both the parties were noticed. But in para number 9, my lord, with
You have not said that,
it
yes,
is
yes.
not said.
Yes.
The last paragraph question, it is not specifically admitted. Check off.
Yeah, with your vast experience, Mr. Das, you know that has got no meaning. That has got, it has to be specifically denied.
Yes, sir. प्रथम आरंभ रू फिटा लेखिकी तापर रिप्लाई टा दिया जाए सेटा. That is in all paragraphs supposed to be obliged.
Item 15,
Well, posting to
22nd, 29th.
20.
Item 15. Okay, no. Pass over.
Item 16.
Yeah, 15 টা good extension of time mentioned. This is dispose of case for that. Just for time.
My lord, on behalf of
Just. Time is extended till end of June 2024 for disposal of the case as requested by the court below. Yes.
Item 16.
May I please, my lord, I'm appearing for the petitioner wife, my lord, for the,
my lord, I am appearing for the opposite party husband.
my lord, for the transfer.
On the last occasion, your lordship has directed us to take instruction.
Without mediation.
Mediation.
All right.
Yes, let the matter go for mediation.
My lord, as per my instructions, wife is not,
Not ready.
no,
Not ready for mediation. Atara कौन करेगी?
on the matter. My
They will hear the matter. Hear the matter.
matter.
Let the matter come next week.
Ms. Pandya, learned counsel appearing for the opposite party husband, submits that her client is ready for discussion regarding settlement. Mediation is ready for mediation. Stop. Ms. Rai, learned counsel appearing for the petitioner wife, however, submits that her client is not ready for mediation. In such way, the matter. Therefore, adjournment is made on behalf of the opposite party husband. Let this matter on 22nd April for final disposal.
Obliged, my lord.
Item 17. May plus. As per application at the instance of wife, my lord and senior is appearing on behalf of the opposite party husband.
You are appearing?
Oh, yes, my lord, I had earlier appeared, but that Vokalatnama was attached to the CMAPL filed by my friend. So today I am filing the.
Ranjan Kumar Raut, advocate and associates have entered appearance for the opposite party. The filing Vokalatnama, the same be kept in record. The name of Sri Raut and associates
My lord,
declared in the cause list. Yes.
My lord, your lordship may dispose of the application.
Is the transfer application?
My lord, transfer application 2022, my lord. Earlier, my lord, CP was filed for restitution of conjugal right. Restitution was allowed in my favor, but wife did not join. Thereafter, after 1 year, I have filed this application for divorce for non-joining with me, not joining the company of So if she desires to contest the case and in the court of the Honorable Learned Judge Family Court, Dhekanar, I don't have any objection. But
Can I record it?
Yes, madam. But only difficulty is I am staying in Bangalore and she is staying in Dhekanar. So
you can appear virtually by submitting an application.
My lord, advocate has to appear. My lord, only target maybe.
Advocate, because you see in these matters, conciliation, the party's presence is necessary. Sometimes.
Yes.
Not on every day, but sometimes. So I grant you that liberty to, if necessary, you can move an application. People are appearing from Bangalore. I know. As a matter of fact, some people are appearing from Bangalore.
True, we'll see. My lord, only target maybe within 3 months, let it be restored.
ये कौन बाबा केतल होची केतल होन ट्रांसफर एप्लीकेशन ट्रांसफर एप्लीकेशन नहीं खोलू नहीं कल The wife has approached this court. The wife of opposite party has approached this court seeking transfer of CP number 924 of 2022 pending in the Court of Learned Judge, Family Court, Bhubaneswar, to the Court of Learned Judge, Family Court, Nekara. The after case has been filed by the, you have filed it? Yes. By the petitioner wife seeking divorce.
No, my lord, petitioner filed. My husband filed, opposite party.
By the opposite party husband. Under section 13(1) of the Hindu Marriage Act for a decree of divorce. It is submitted that the petitioner wife is presently residing at Dhankanar with her parents, as there was a dissension in her marital life, which led the parties to file different cases against each other. It is further submitted, it is submitted that the petitioner is unable to, he is not in a position to visit Bhubaneswar on the date of posting of the case. On the other hand, when counsel for the opposite party submits that his client is presently residing at Bangalore, for which Bangalore, stop. He, however, he further submits that despite such fact, his client has no objection to the proceeding being transferred from Bhubaneswar to Dhankanar. Stop. It is, however, requested that the petitioner being at Bangalore may be permitted to appear through virtual mode whenever it is necessary, and through his counsel on other dates. Stop. Considering the submissions as above, and the fact that the opposite party husband has no serious objection, has no objection to the proceeding being transferred from Bhubaneswar to Dhankanar, I am inclined to allow the same. Stop. The transfer application is allowed. It is directed that the proceedings in CP number, whatever, CP number 924 of 2022, your family code 1 or 2?
My lord, family code 1, sir. Well,
pending before the modification pending before the learned judge, family court 1, Bhubaneswar, shall be transferred to the court of learned judge, family court, Dhankanar. Stop. It shall be open to the opposite party husband to move appropriate application seeking permission to appear through virtual mode. Stop. If such application is filed, the same shall be considered by the court below in accordance with law, as also taking note of the fact that he is a resident of, he is presently residing at Bangalore. Stop. Further, the court below shall not insist upon the physical presence of the parties if unless it is absolutely necessary. That's it.
And the case proceeding may be concluded within 3 months.
Further, that apart, the court below shall do well to conclude the proceeding as early as possible, preferably Within a period of how much? 6 months?
3 months, my lord.
3 months or sorry,
By end of October, my lord.
6 months how the
My lord, by 6 months. My lord, may I pay one thing, my lord? Instead of Bhubaneswar, one quoting session will suffice the matter.
Courting session will कर दी था देखिए.
Aye.
Courting session over the matter.
I will intimate the court master.
By the end of this day, if you can obtain the instruction.
Today within
बस सेटा है.
few minutes I will.
नॉट पुनी modify करो.
हाँ, असुविधा. Nice, man.
May I please all of you. All the petitioners who have been selected as ASA Karmi by a duly selected constitutional selection committee, they have challenged their cancellation of selection list under Annex 3. The authority having without authority, without any stipulation there in the guidelines or in the advertisement itself, the authority have cancelled their selection without any reason. And in the counter, they have said, my lord, mostly they have said that since there is no mapping area prior to the advertisement, they have cancelled the selection list first. Second thing that they have said that since there is a public, one person made complaint, they have made an inquiry and found these are the illegalities for which they have cancelled.
Let us see the original advertisement.
Next was.
भुवन एनएससी के हाथ में आशा चौहान निमंत्रित दरखास्त आह्वान करा जाउछि. So you are an applicant, all of you. How many petitioners?
6.
6. So you are applied.
5 petitioners.
You are applied. Then you are selected.
You are selected and Annex 3 is the notice.
Annex 2 is Namita Patra, Holy South, Sujata Bera. 6 জন অছতি.
6 জন 5 জন অছন্তি petitioner.
আচ্ছা. Then what happened? This is the notice. Annex 3.
Annex 3 is the
selection process hereby cancelled. A fresh notification will be published soon after. Any interim order passed by this court?
Yes, sir.
What is that order? Any appointment made in respect of ward numbers 3, 7, 8, 11,
22, 8, 2022.
pass after shall be subject to result of the application. All right. Then what happened?
Counter file, they have mostly said that since there is no mapping area.
What is the mapping area?
Mapping area of the service area of the ASA Karmi. But that is a false statement. In the regional, I have said you also kindly see Annex 6. There was a mapping area.
Your rejoinder is not on record. Are you rejoinder देखलो? इधर नहीं scanning है You file a rejoinder?
Yes, sir.
Which paragraph of the counter you are referring to?
Rejoinder lordship.
नहीं आपको क्या counter को paragraph से कोई चिंता? Which rejoinder. On the basis of that inquiry.
Paragraph 9 on.
9. Yes, la कौन फोकड़ दला inquiry कर दला अपना तो मेहमान को बाहर कर दे.
बाहर पर सिलेक्शन ହେଇଥିଲା फाइनल अप्रूवल ହେଇନଥିଲା.
सीते की जो ना inquiry कला ये inquiry कौन अपना what inquiry you head? What is that inquiry? Where is your report?
Report well to have annexed.
You are next.
Page 23 annexed to HB2.
Yes.
Inquiry report, where is that inquiry report? Annexure?
Annexed to HB2.
H/2, yes.
Page 23. Page 23.
In reference to letter number 8, team comprising DPHO referral. Where is that complaint which led to this inquiry? Have you enclosed?
I think so. I have given. Page number 21.
Page number 21.
Yes, well.
21 is referring to the grievance petition of Ms. Deepa Malik, Ms. Sobita Naik and Radha Sahu simultaneous communication letter. Where is that original?
Page note.
Where is that original grievance petition?
Page note 21 of our counter, madam.
Page number 21 of your counter. Yes, এই যে ওড়িয়া রে লেখা আছে।
হ্যাঁ দীপা মল্লিক।
ভুবন গোষ্ঠী সংস্থা দ্বারা আমি আবেদনকারী বিগত অনুসারে সঠিক সত্য পূরণ করতে। Basically, they have said that they were also applicants, but they were never called by the selection committee.
Properly advertisement ହେଇନି proper mapping ହେଇନି ସେମାନେ ଯେତେବେଳେ allegation ଟା କରି ଏତିକି ପାଇଲେ after receiving this allegation when they conducted the inquiry during the inquiry process they found other irregularities.
Let us see.
That is what they have observed in annexure H/2.
Yes.
No, guideline does not provide to entertain the public grievance petition also.
No, it's not a question of public grievance. They say that they were the applicants themselves. You come to
Page 21.
page 21.
Yes, sir.
Huh? Page 21.
Basing upon this complaint, they have made the
আবেদনকারিণী বিজ্ঞপ্তি অনুযায়ী সঠিক শর্ত পূরণ କରି ନିର୍ଦ୍ଦିଷ୍ଟ ବିଜ୍ଞାପନ ପ୍ରକାଶନ 10 ଦିନ ମଧ୍ୟରେ ଆବେଦନ ପତ୍ରଟିକୁ ଦାଖଲ କରି ପ୍ରାପ୍ତି ସ୍ୱୀକାର ପତ୍ର ଅବଗତ ହୋଇଅଛୁ। So they were applicants. They are not general public. They are not general public. So they have got every right to submit a complaint if they are not made part of the selection process.
even if there was an inquiry basing upon this complaint, my lord, their case is that since there is no mapping area of the service area of the
All right.
but they are a mapping area. But prior to notification of the advertisement, there was a mapping of the
So let us go one by one. What is it? They say for this financial year, 6 numbers of ASHA have been sent. Prior to the notification, prior to the notification, the selection subcommittee has not finalized the ASHA service area by mapping. The ASHA notification has not been done for whole area without mapping. After publishing of notice, it is supposed to make 6 grounds have been taken to cancel.
Yes.
Let us find out whether they are justified or not. Because as it appears, the complaint was on different grounds.
Yes, ma'am.
The grievance petition was raised, sir, that has not been answered. That has not been touched at all. Excepting for mapping thing,
Yes, ma'am.
nothing has been touched. Don't you find from the report?
Yes, madam.
It has proceeded on a different, the third case has been made out.
Well, when certain allegations were there with a specific person, that had not been taken into consideration.
Generally, they have considered.
They have considered that once the irregularities are there in the selection process itself, so without delving into the issue of personal, and in the result of my lord even, the petitioner says that whatever the irregularities have been committed, those irregularities have been committed at the level of the authorities. For that reason, the petitioner should not suffer.
Obviously.
Fact remains, once the irregularities are
And
there,
this, for example, come to the, as per ASHA notification number 288 dated 13/8/2000, the last date for submission of application was 22/8/2021 Sunday, which was a holiday, for which applicants were unable to submit. See, something very strange. Whenever it is a holiday, it is always understood that on the next day you can,
Yes, sir.
next day before the close of the court office hours. ASA notification was published for whole urban, but after submission of application form, whether the subcommittee has decided to select from particular words and the proceeding of the selection committee was not prepared. No, you have to justify this, the inquiry report.
Yes,
Whatever it is, whatever the grounds have been taken, you have to prove to the court that these are, cogent grounds. Grounds that are acceptable, because in the process, you see, they have only been selected, they have not been appointed.
No.
So they,
Before
apart from
approval of
having a
the
legitimate
selection-
expectation, they do not have a vested right.
Before
That is the law.
approval of the selection, my lord, this has been.
But if the advertisement is cancelled, it is equally well settled that it cannot be an arbitrary action. It has to be on some basis.
The advertisement not been cancelled, the selection. has
I mean,
been
the
cancelled.
selection, whatever.
Yes.
I'm saying the advertisement means the selection.
But
You cannot simply cancel it
Yes.
at your own will.
No,
It has to be supported by cogent and sound reasons. Whether these reasons can be treated as cogent or sound has to be, you have to justify that. You have to show that. Let us go one by one.
yes.
Prior to the notification, the selection subcommittee has not finalized the ASHA service area by mapping.
Yes.
Where are the guidelines relating
My lord, it
to
has been
ASHA?
given. Annexure 5 panel.
Another 5 to the writ petition.
Writ petition, page note, it starts with page note 15, my lord. My lord, may I be permitted to address the honorable court, my lord, on each issue, on each point, my lord, by giving a short notes of submission, my lord. After referring to this particular guideline.
All right. I'll call it next week then.
Next week, man. It would come issue on 22nd.
All right, heard in part, let's this matter on 22nd April. 22nd April लिखे तरह से निकला, part heard? Part heard नहीं? पहले 22nd April. The mediation failed.
Medicine failed, though, but why did not agreement?
Secretary DLS Burger has submitted a report stating that the mediation between the parties has become unsuccessful. Yes.
The merit melod, this is case melod. The peasant petitioner people, it is the husband melod. And both the petitioner and opposite party, they are residing, they are serving under Ottavira police station, which is in the Burger district melod. Just because 15 kilometers away from the Joseph of the melod, the family judge, Burger melod. The wife melod, he deliberately filed the petition before the judge family court Bolangir melod, which is para nearly one melod 80 kilometers melod. 80 kilometers. The case both the marriage took place in the year 97. They are blessed with one son and daughter. The daughter is now nearly 16 years, 26 years. She is also serving. The son is also proceeding study in Delhi. The president petitioner is ready to the residing of the wife, but she is not interested. My only prayer was to call the Ottavira police station.
Yes, what do you say, Mr. Sahu? You are at Ottavira. You will also be, it will be inconvenient for you to travel to Balangir. If both parties can agree, we'll direct the case to be transferred to Burger. You think about the matter, take instruction from the clerk.
I will take instruction, yes.
Hearing of the bail application, hearing of the transfer application is taken up. Sri Naik Learned Counsel for the petitioner submits that since both parties are presently working in and around Burger, it would be convenient for both of them to attend to the case at Burger than Bolangir. The Sahul Learned Counsel for the opposite party wife wants to take instructions in this regard from his client. Is this matter next week?
Yes,
Next week.
Interim order to control.
Interim order to control.
Yeah, close. Can you see last order here also? Last occasion also directed to solve for the report from the postal whether the notice has been issued to the OP or not. Notice is there, my lord. The notice has issued to Jyotish Vishwal.
Notice has been.
Yes. But he has not up.
Court selection. As reported by the senior postmaster, Cuttack GPO. Notice of the case has been delivered to Jyotish Vishwal, Secretary, opposite party. There is, however, no appearance. Kebe delivery ala? On 5/12/2023. Stop. There is, however, no appearance from his side. What to do?
File this application to transfer the CP proceeding from Jagatsinghpur Family Court Judge Jagatsinghpur to Family Judge Cuttack. The ground lord, I am belongs to Neari, and the Jagatsinghpur is more than 100 kilometers away from my house, and so for Cuttack is only 30 kilometers. If I will go to Cuttack, first I will come to Cuttack. Thereafter, by giving another bus, I will go to Jagatsinghpur. Second lord, I'm only a 3 years child. I have no male member in my family.
The petitioner is the wife of the opposite party, and petitioner, being the wife of the opposite party, has filed this application seeking transfer of CP number 186 of 2023, pending in the Court of Learned Judge, Family Court, Jagatsinghpur, to the Court of Learned Judge, Family Court, Cuttack. Said case has been filed by the opposite party husband for divorce under Section 13 of the Hindu Marriage Act. It is the transfer application has been filed on the ground that the petitioner is a resident of Oraspur, which is at a distance of nearly 80 kilometers from Jagatsinghpur. Further, she has a small child, aged about 3 years. As such, it would be inconvenient on her part to travel to Jagatsinghpur to attend to the case on each date of its posting. This court has already observed that despite sufficient notice, there is no appearance from the opposite party. Taking into consideration the convenience of what is the opposite party doing?
Now he's serving at Jagatpur.
Jagatpur.
Yes, sir.
Would ever let you
Subsequently, I got the information.
All right. You are Mr. Goya. You are?
I'm Mr. Swain.
Mr. B.K. Swain, 11 counsel appearing for the petitioner, submits that as per his instructions, the opposite party is presently working at Jagatpur, and therefore it would also be convenient if the case is transferred from Jagatsinghpur to Cuttack. Considering the submission as above and the grounds cited for transfer of the case, I'm inclined to allow the same. It is the transfer application is allowed. It is directed that the proceedings in CP number 186 of 2023, pending in the Court of Learned Judge, Family Court, Jagatsinghpur, shall be transferred to the Court of Learned Judge, Family Court, Cuttack. Yes.
Item number 21.
I am asking for continuous.
You are okay.
May please.
Shri Umesh Chandrajana, advocate and associates have entered appearance for the opposite party by filing Wakalatnama in the court. The same be kept on record. Their names be reflected in the cause list. Yes, any chance of mediation?
Sir,
Mr. Jana?
restoration of conjugal right is pending in Bhubaneswar by husband. 125 petition is pending by wife in Bhubaneswar. And so my humble place is Bhadrak is 150 kilometers. Sir. And may kindly transfer this case because here is a chance of cancellation. Because
Why? I am asking you now. If there is a chance of conciliation, you can have it at the High Court Mediation Center. I can send it to the Mediation Center at in the High Court.
okay, sir.
Yes. It is submitted that the nature of dispute between the parties is such that an attempt can be made to resolve the same amicably. So, in view of such submission, the courts be placed before the coordinator, Odisha High Court Mediation Center, who shall do the needful. Stop. The parties are directed to act pursuant to notice, to appear pursuant to notice issued by the mediator and to render full cooperation in the mediation proceedings. Place this matter on 6th May. In order to continue.
Item 22. May I please? Madam, petitioner is the wife minor. She has filed a transfer. He has filed this transfer petition to transfer from Family Court Baleshwar to London Judge Family Court Barampur.
Mr. Jannah had appeared.
Madam, opposite party in one date appeared and
Last time did not appear.
Madam,
Counsel for the petitioner is present. There is no appearance from the side of the opposite party. On the last occasion also there was no appearance. The transfer application is therefore taken up for hearing on merits. Yes.
My lord, the opposite party has filed a divorce application before a London Judge Family Court Baleshwar. And this petitioner wants to transfer that application on the ground of distance, and there are two applications also pending, and the opposite party is appearing in the court of Barampur, my lord, in DB case and also in VR case. Therefore, my lord, on those two,
You are resigning at
Barampur, my lord.
Well, we'll allow it. The petitioner is the wife of opposite party. The petitioner, being the wife of opposite party, has filed this application seeking transfer of civil proceeding number 728 of 2022 pending in the Court of Learned Judge, Family Court Baleshwar, to the Court of Learned Judge, Family Court Barampur. Stop. It is stated that stop. Therefore, transfer has been made on the ground that the petitioner is residing at Barampur and has also filed two other cases against the opposite party at Barampur, being the proceeding under section 125.
DB, my lord, section
125 to file question,
my lord.
125 of CRPC, and the other under section 12 of the DB Act, PWDB Act.
PW.
The opposite party, it is submitted, has appeared in the aforementioned cases. It is further submitted. It is submitted by learned counsel for the petitioner that being a resident of Barampur and being a lady, it would be difficult on her part to travel to Baleshwar on each date of posting of the case, as Baleshwar is at a distance of more than 350 kilometers from Barampur. Further, she is dependent on her parents, as she has no income of her own. So, as already stated, there has been no appearance from the side of the opposite party on the last two occasions. on the last occasion, since the last occasion. Considering the prayers, this court finds no reason to keep the application pending any longer. Stop. The transfer application is therefore allowed. It is directed that the proceedings in CP case number so and so from such and such to allow kar do. Yes.
So,
So
item number 5. Please, Your Lordship. In item 5, the present petitioner, they are working as aspirant primary teacher. Now, their short grievances, Your Lordship, they have passed the OTED examination, which is mandatory for their regularization. But what they have done is, the normal course is first is junior schematic, after 3 years, junior teacher contractual, thereafter assistant teacher level 5. Within a period of 6 years. Now, I have passed the OTED examination in 2019. So they have regularized me, my services from 2019, Your Lordship. But whereas in other cases of other teachers, they have done it from the date they have completed 6 years of service. Now, the similar matter before the coordinate bench, Your Lordship. I beg apology, but that is the fact.
no, you don't have to beg apology. You don't have to beg apology. You have got every right to. The only thing is that when somebody brandishes an order and says that it's covered, I am very, very slow in accepting it. Unless I go through.
It's a very simple order. They passed. They asked us to make a representation before the appropriate authority.
So you say that. Representation that will be covered better.
I'll notice finally you put it.
You have filed any representation?
No, Your Lordship. I'll make a representation.
All right. The petitioners. How many petitioners are there?
1, Your Lordship.
1.
Yes, Mr. Das will discuss.
Yes.
Granting them liberty to.
In fact, I was going to submit that there has been no decision from the side of the authorities.
The petitioner has approached this court seeking the following relief. The limited grievance of the petitioner is that she was engaged as she was initially engaged as Sikha Sahib, and thereafter as junior teacher after completion of 3 years. Stop. Subsequently, she was regularized as a teacher 3 years thereafter. Stop. Her grievance is that she should have been, her date of regularization should relate back to the date on which she was appointed as Sikha Sahib. That is 2018.
18.
2018. At page 48. At page 48, they regularized me from 21/12/19.
But her regularization was given effect to from data कितने
2019.
21/12/2019. This court finds that it is for the concerned authorities to take a decision in this regard at the first instance. Stop. The petitioner, without approaching the concerned authority, has directly approached this court. Stop. The writ application is therefore disposed of, granting liberty to the petitioner to submit a representation highlighting her grievances before the Director of Elementary Education, opposite party number 2, within a period of 4 weeks. Stop. If such representation is submitted, the opposite party number 2 shall consider the same, consider and dispose of the same in accordance with law within a further period of 2 months under intimation to the petitioner. Yes.
So item number 6 is similar.
Same.
Data relation 9/23.
ठीक कर रहे हो, हाँ?
9/23.
9/23.
So item number 7.
The petition was engaged as a mother non-secure. And while he was continuing, he was regularized in 2017. And his prayer is, my lord, in view of the guideline, he is to regularize at 6 years after he was taken as a non-secure.
Come to a prayer.
But direction by the directing the opposite party to treat the petitioner to be observed as Sikha Sahib with effect from 358. Since the petitioner engaged as vacant post of Sikha Sahib and having the same qualification as part of Sikha Sahib,
and performing the same duty that is available for. You said something about Gana Shiksha? My lord, petitioner was engaged as a Gana Shiksha in the vacancy of the Shiksha Sahayak, and this honorable court decided in case of the Dhananjay Dev, which was subsequently confirmed to the apex court, that those Gana Shiksha, they are adjusted and they are appointed against the vacancy of the Shiksha Sahayak. So the policy and the principle of Shiksha Sahayak, the career advancement policy, applicable to the Shiksha. The same order we have passed, I think.
They have to represent and that be
That is to be considered in the light of that only.
So that Dhananjay Dev amra hichi order se korba.
OP1.
So item number 8.
May I please. But here petitioner is after the Gram Rozgar Sevak matter 23/11/2007. While he was continuing as such on 2/11/2013, he was transferred to Jharban block from his own block, which is 150 kilometers from its native. Thereafter, on 25/8/2023, the government issued a guideline stipulated GRS, Gram Rural Sevak, should be allowed to work in his own block, subject to vacancy. Thereafter, on 1/12/2023, the petitioner.
Where is the transfer order?
Pardon,
Where is the order of transfer?
order of
Transfer kind?
order of transfer lordship. Annex 3, page 16, lords.
In persons of PNR, the following Gram Rozgar Sevaks are reversed transfer posted to the GPN block on setting the first month. Page 17 is nothing, absolutely not visible.
Lords, which is transfer order.
Imagine it is not visible at all.
Sorry, Mike.
None of the names are visible. Not a single name is visible. Page 17 is the hard copy.
16, lords. I'm sorry, 16.
16 is the order.
Yes.
The list is at page 17. Not a single word is visible. Okay?
On bottom, 4th, Manbut Singh.
Manobodh Singh.
I get.
Kolapani.
Kolapani to Jharban. He was transferred. 150 kilometers.
150?
I get.
So you have submitted a representation?
I get. Annex 5, page 21.
Then?
stated to have been received there on 1/12/2023.
There is an endorsement. Collector officer or endorsement you achieve. 1/12/2023 it has not been disposed of as yet.
No.
And you must have been relieved?
If not,
No.
disposed of.
I have petition was transferred on 2/11/2019. My prayer is since
now you want to be transferred back to your
yes. On the basis of the guideline.
Was that
Annex 1?
Yes. The petitioner will dispose of, will direct the collector to consider. He was transferred in 2019. He is working at Jharban. Now he wants to come back to his own house. It will be considered upon.
Annex 1.
The petitioner approached this court seeking the following relief. The case of the petitioner is that he was appointed as Gram Rozgar Sevak. When were you appointed?
On 23/11/2007.
On 23/11/2007 and was posted at Kolapani GP. Stop. It is submitted that he was by order dated 2/11/2019. The petitioner was transferred to Jharband GP. Stop. Since then, he has been working at Jharband. Stop. It is stated that Jharband is at a distance of about 150 kilometers from Kolapani, which being his home GP, which is his home GP. Stop. Because of such long distance, it is proving to be inconvenient for him to attend to his family, which resides at Kolapani. Learned counsel for the petitioner draws attention of the court to the guidelines. Guidelines, it is an order. An order dated 25/8/2023, issued by the government in PR and DW department, wherein the following has been provided. Wherein inter alia the following has been provided. They provided that subject to vacancies with a pratham lekhai seat of court. As far citing the above provision, the petitioner wants to be transferred back to his home GP. This court finds that ventilating his grievance as above, the petitioner has submitted a representation to the collector Bargad on 1/12/2023, which also appears to have been received in the collector's office on the same day. Said representation is pending.
Stated to be pending.
Is stated to be pending. Since the petitioner has already approached the competent authority for redressal of his grievances, the writ application is disposed of, directing the collector Bargad to dispose of the representation of the petitioner in accordance with law within as early as possible, if not already disposed of.
Yes.
As early as possible, preferably within a period of 2 months. Let him give him an opportunity of personal hearing. After granting an opportunity of personal hearing to him, stop. So that he can say whatever is.
Let's say taking into consideration annex.
I have already quoted it to you.
Objection.
And he must cooperate because since your lordship have fixed it, your time duration, he must cooperate.
It is needless to mention that the petitioner shall appear before the collector pursuant to notice issued. Yes.
So that no 9.
On last date, my lord, you filed an additional affidavit on the last occasion.
Yes, they filed an additional affidavit, my lord. Pursuant to your order dated 27.
You are filing it today.
नहीं स्मूथ कोड में पाइल पर देले सर मतलब जे ऑब्जेक्शन तो बोल रहे सर
सर ऑब्जेक्शन दो
हां सर टिके खाली
आगु फाइल करेनी
सब काय आसीबन सर सामे देवन फाइल
नहीं तो कॉपीटा में आउतर देलेनी
किसी पे नथि लइला आसीले सर
नहीं हम स्टेट को देवर मत मु
आपण अपिल करतोनी आज्ञा
नहीं प्रश्न दरकार
यस
नहीं आपण तो स्पेशल
प्रश्न मु देखि
देखिन सर निश्चय कहबे
सर मु सेति नै सर स्पेशल ऑफिसर पे अपिल करतोन गवर्नमेंट पे अपिल करतोन
No, Mr. Rathore, you may not have filed it validly before the counter, in the counter. I am thinking that it will not be tagged to the case. That is all right. Yes. But what prevented you from serving a copy on the other side, Mr. Jana?
Sir, I affidavit question not level they pardon, sir.
No, there is a time option.
Sorry.
No, sorry, time to say he has received the objection in the court. Will I not grant him time to go through it? We'll take it up tomorrow. कौन अच्छी तरह ऑब्जेक्शन अच्छी है कौन
मैंने टुमारो मो रही
ये देखो परदिन परदिन की माना करो
अनेक्स रोड को ए बाई 1 ना ने 6
दो इन देबे
कंप्लीट दे डॉक्यूमेंट दे
आज्ञा दो सॉरी सर ये परदिन कौन पाठर बैठर अछि तो पाठर पाठर अछि आप चट्टा पाठर अछि ताले 12 तारीख अछि सर 12 तारीख That's Commissioner Rathore. You should have served a copy so that the matter could have been taken up today. You would have been ready with this objection. Because you are also enclosing a copy, I find. Sir, no, sir. 12:05. Sir, upon sir, I'm sorry. No, Mr. Rathore, you have given a list. Sir, you have said personal file, 15 numbers, land records, affiliation files, recognition files, permission file, all those things you have mentioned. Sir,
ଆପଣ ଯୋଉଟା କହିଛନ୍ତି ସାର୍, ମୁଁ ସାର୍ ବୁଝି ଅଫିସ the peon attached to Mr. Jena, I contacted, ସେ ଆସିବେ ନା ସେ ଆସିପାରିବେନି, ଆପଣ ଯଦି ଫାଇଲ କରିବେ ତାହେଲେ ଆମେ ଏହା ସାର୍ ବିଶ୍ୱାସ ସମିଶନ ଷ୍ଟେଟମେଣ୍ଟ, ସୋ ଦ୍ୟାଟ୍ ଇଜ ହ୍ୱାଇ ସାର୍ ମୁଁ ତାଙ୍କୁ ଅପେକ୍ଷା କରିଥିଲି।
Sri Dian Ratha files objection to the additional affidavit filed by Sri Jena on the last occasion in court. Sri Jena wants to take instructions on the objection filed by Sri Ratha, list this matter on 15th. That is requested to come ready for final disposal on that day.
Sir.
No further adjournment. I have heard it enough.
Yes, my lord, I have.
Yes.
For the second case, I am the petitioner. Prahlad Sahu. I am the president of the palace.
Second case is 31993. That is the third case.
Yes.
Yes.
So there is one stay in 30 WPC, for which I am not able to function as president of.
No, I understand, but on 15th, that is why I am making a request. I passed that order also that parties should come ready for final disposal. No further time should be granted.
I filed an application in that case, my lord. ସେଥିରେ ସେ ଗୋଟେ କପି ଦେଇଥିଲେ, ମୁଁ ସେଟା ବକ୍ସ ଫାଇଲ କରିସାରିଛି, ଆଉ ମୁଁ ନମ୍ବରଟା ଦେବେ ସାର୍, ସେଟା ଆଇଏ ନମ୍ବର
ଦେଇଦେବେ, ଲେଖି ଦେଇଦେବେ।
ଆଜ୍ଞା,
Yes. Then
ପାସୱାର୍ଡ ଆଇଟମ 11
12 dispose of କରିଦିଅନ୍ତୁ। Non-appears dispose of।
ପାସୱାର୍ଡ ଆଇଟମ ନମ୍ବର 13
So 12 ଟା ତାଙ୍କର ବୋଧେ, 12 I am disposing it of।
ମୋର 12 ସରି
Oh, sorry, yes. Oh. Item 13,
paper 2 weeks, my lord, time.
2014 matter, 2 weeks for.
Next week, my lord.
Why next week?
Well, that's not available. A personal difficulty.
What personal difficulty? Why don't you argue? Is it necessary that Mr. Das will argue every case? Why not arguing? What matter? Matter टा कौन है कौन नहीं?
Matter मतलब release the block grant salary.
Block grant इसी करेंगे कौन? OP number 3 to release the area block grant of petition in the untrained scale from 1/1/2004 to similar matter. I think we are considering somewhere in some other case.
Next,
With respect to this one.
Therefore, argument is made on behalf of Mr. Samir Kumar Das. Let's this matter next week.
In fact, well, in this case, we have filed a counter. Though there was a direction to solve a copy matter, today actually he received.
Yes.
all is well.
item number 23
Lordship, in this case, I have filed a IA for interim bail. Lordship, I have a prayer, Lordship. This is the legal aid matter. The case ର present status ଟା କଣ ଅଛି ମୁଁ ଜାଣିନି, ସେ ଏବେ ଅଛି କି ନାହିଁ ବେଲ ରେ ଯାଇଛି ଆଉ ଜାଣିନି ମୁଁ, ଷ୍ଟାଫ ସହିତ ମୋର କଣ୍ଟାକ୍ଟ ନାହିଁ, ଯେହେତୁ legal aid matter ମୋର କଣ୍ଟାକ୍ଟ
But you have filed
interim bail. ପ୍ରଥମେ ସେ ଆଗେ ବେଲ ନେଇଥିଲେ, ସେ 3 ଲକ୍ଷ ଟଙ୍କା କ୍ୟାଶ ସିକ୍ୟୁରିଟି ହେଇଥିଲା, ସେ ଯାଇନଥିଲେ, ତାପରେ ସେ ମଡିଫିକେସନ ଫାଇଲ କଲେ 1 ଲାଖରେ, 1 ଲାଖରେ ବି ଗଲେନି, ତାପରେ ସେ ଲିଗାଲ ଏଡ୍ ଅଫିସ କୁ ପ୍ରିଜନର ପିଟିସନ ପଠେଇଲେ, ମୋର ମତେ ବେଲ ଇଣ୍ଟରିମ ବେଲ ନିଆଯାଉ, ମୁଁ ଗଲେ ପଇସା ଦେଇଦେବି, ତାପରେ ଏପର୍ଯ୍ୟନ୍ତ ସେ ମତେ ଆଉ କିଛି ଖବର ମୋ ପାଖରେ ନାହିଁ ଯେ ସେ ବେଲ ଯାଉଛନ୍ତି କି ନାହିଁ।
counsel for the petitioner.
Not my name is not reflected.
Okay. Your good name, madam?
Mandakini Ponda.
Ms. Mandakini Ponda appears for the petitioner through legal aid. Stop. She submits, comma. She has known, she wants to take some instructions from her client regarding his present status. Hello. Next week? Let's this matter on 22nd April.
22nd.
item number 24
But it's for extension of time, second time extension.
Second time? Why?
But except the petitioner number 4, that all the other persons were surrendered and they have been released on bail, this injury being simple in nature.
2 weeks further time is allowed to petitioner number 4 to surrender.
item 25
Correction be made accordingly. Is that correction? Yes.
Next item number 1.
Let's see, item 1, praying for Passover.
Item number 2.
Passover.
Item number 3.
May please Doswell, on behalf of Mr. Doswell, my lord, here is the petition release on my interim bill 2 month, my lord. His release in 13/3/2020.
It is on interim bill.
My lord, 2 months, my lord.
2 months to 6 weeks.
6 weeks. As per order, my lord, by 22/1/24.
2 months yes.
2 months.
So he has surrendered.
No, let's say release la 13 March 13/3/24. My lord.
It is submitted that pursuant to order dated 22/1/2024, granting 2 months interim bail to the petitioner, he availed the benefit of such order only on 13/3/2024. As such, the period of interim bail is not yet over. Let this matter after 15th May.
Oh, bless you.
Item number 4.
I am saying, my lord, on 15th next week, but on that day, my lord, the co-acute bail applications are fixed on the same day.
Please this matter will be commencing 15th April.
Document.
Item number 5.
May I please your lordship? My lord, here in this case, the charge sheet submitted for the offence silence under section 302 and 34 of the IPC, my lord, and the charge sheet submitted against 4 persons, my lord. The 4 person, out of them, 1 person being a CCL already acquitted, and 1 person released on bail on 13/3/2024.
Sashikanta Mishra.
My lord. My lord.
It happened the regulator son So unknown affair. Then what happened?
My lord. Oh.
Is it a split up trial?
No, my lord. No, yes, my lord. Split up trial. 1 for the CCL and 3 persons in this. My lord, only the person inside custody since 9/4/2021, and the one unknown FIR is registered, and the present petitioner being on the confessional statement and 27 of the evidence are.
Deceased was in love with your Shivanath.
My lord.
So deceased was in love with your sister.
My lord.
You were opposing it.
My lord, that is the allegation. My lord.
That is what you are saying. It is not a finding.
My lord.
That is the allegation.
My
so what is the material against him?
My lord, that death is due to asphyxia as a result of aspiration of blood.
Aspiration of blood. Caused by?
Lathi and knife. Knife was, my lord. Spring knife and lathi, it was seized from the
27 discovery.
My lord.
Yes, then?
And some of the witness, CDR report is that they were all present and they were talk with each other. And some of the witnesses were examined. 8 witnesses were examined. That the installment, he was not examined. Hon'Ble CORAM, before whom there was extrajudicial confession of the present petitioner. She was not examined. And Raja Das, who was last in theory, he was also not examined.
Yes, ma'am.
These material witnesses, they were not yet examined.
Not yet examined.
Right.
Trial is in progress. Why don't you renew your prayer after examination of these 3 witnesses? Yes.
My lord, on the similar footing, one of the co-accused already released.
Let us see that order.
My lord, can you have a glance on that order?
Justice Satpathi's order.
No, my lord, your lordship's order.
My order. Thank you. He He was on implicated on the basis of the confession of the co-accused.
My
But in your case, there is a 27 discovery. There is a last seen theory against you. So all these factors are there. There is evidence. You don't stand on the same footing as Purnu Bagh.
that last scene theory with one that Pritam Bagh, who is
Let us read it. Let us read it. What will you?
Madam. That is Raja Das, madam. ମୋ ନାମ ରାଜା ଦାସ ବଂଶ। ଆଜି ଆପଣଙ୍କ ଆଗରେ ଏ କେସରେ ମୋ ବୟାନ ଯେ ଆମ ଘରେ ଗୋଟେ କିରାନା ଦୋକାନ ଅଛି। କୋଭିଡ କଟକଣା ଲାଗି ଆମର ଦୋକାନ ସନ୍ଧ୍ୟା 6 ବଜେ ବନ୍ଦ ହୋଇଯାଇଛି। ଆମର ପଡାର ଜଗନ୍ନାଥ ସାହୁ ଓରଫ ମିଟୁକୁ ଆମେ ଜାଣେ। ଗଲା ତାରିଖ 4/4/21 ରାତି 11:30 ବେଳେ ଆମର ପଡାର ଜଗନ୍ନାଥ ସାହୁ ଓରଫ ମିଟୁ 2 ଜଣ ପିଲାକେ ଧରି ଆମର ଦୋକାନ ପାଖେ ଆସିଲେ। ମତେ ଉଠେଇ ମିଟୁ ତାର ସଙ୍ଗେ ଆସିଥିବା 2 ଜଣ ପିଲାକେ ପଡାର ପେଡା ଆଉ ବିସ୍କୁଟ ଦେବା ଲାଗି କହିଲା। ତାର କଥା ଅନୁସାରେ ମୁଁ ମୋର ଦୋକାନରୁ 2ଟା ପେଡା ଆଉ ବିସ୍କୁଟ ପ୍ୟାକେଟ ଦେଲି। ଦେଲା ବେଳେ ମିଟୁର ସଙ୍ଗେ ଆସିଥିବା ପିଲା 2 ଜଣ ଗୋଟେ ଗୋଟେ ପେଡା ଖାଇଲେ ଆଉ ବିସ୍କୁଟ ଧରି ପଳାଇଲେ। ଜଗନ୍ନାଥ ସାହୁ ଓରଫ ମିଟୁ ମତେ ପେଡା ଆଉ ବିସ୍କୁଟର ପଇସା ଦେଇ ପଳାଇଲା। ତାପର ଦିନ 5/4/21 ଖବର ପାଇଲି ଯେ ତାରିଖ 4/4/21 ରାତିକେ ଜଗନ୍ନାଥ ସାହୁ ଓରଫ ମିଟୁର ସଙ୍ଗେ ଆସି ମୋ ଦୋକାନ ପେଡାର ବିସ୍କୁଟ ନେଇଥିବା 2 ଜଣ ପିଲା ଭିତରୁ ଜଣେ ଲୋକ ବରେଇପାଲ ମଖନପଡା ରୋଡରେ ଥିବା ଖଦରୀ ଦୋକାନ ପଛପାଖେ ଥିବା ଜାଗାରେ ମର୍ଡର ହୋଇଯାଇଛି। That is the last scene that my lord these persons were present with.
He doesn't identify Shivanath.
No.
He has not said the name of Shivanath.
No. He has lastly seen that the present petitioner with Shivo. That 2 persons with the present petitioner, they were present. He has last seen because they have taken some.
କୋଉଠି ସେ କହିଲା ଯେ ମୁଁ ମାନେ ଶିବକୁ ଦେଇ ଇଏ କରୁଛି ବୋଲି।
ସେ କେବଳ 2 ଜଣ ପିଲା ତା ସାଙ୍ଗରେ ଥିଲେ ବୋଲି କହିଲା।
ସେଥିରେ ହବନି ଏଟା ସ୍ପେସିଫିକ ହବା ଦରକାର ନା ଲାଷ୍ଟ ସିନ୍ ଥିଓରିଟା ସ୍ପେସିଫିକ ହବା ଦରକାର ନା 2 ଜଣ ପିଲା ଥିଲେ କୋଉ 2 ଜଣ ପିଲା ଥିଲେ କେମିତି ଜାଣିବ। ଦେନ୍ 27 ଟା ଅଛି।
ମାର 27 ଟା ହଉଛି ଶିବନାଥ ଓରାମ
ସେଇ ପର୍ସନଟା କେବଳ ସେଇ ପର୍ସନଟା।
ଆମେ ସମୟ ବସି ମଦ ପିଇଲୁ। ପବନଙ୍କ ମଦ ପିଇଥାର ମାରିବାକୁ ସୁବିଧା ହେଲାନି। ମତେ ଆହୁରି ମଦ ଆଣିବା ପାଇଁ କହିଲି। କିଛି ସମୟ ପରେ ପବନ ଲିଟିକୁ ଧରି ପୁନର ସ୍କୁଟିରେ ପୁଣି ମଦ ଆଣିବାକୁ କଲା। ପ୍ରାୟ 2.5 ଘଣ୍ଟା ପରେ ପୁଣି ମଦ ଧରି ଆମ ପାଖରେ ପହଞ୍ଚିଲେ। ସମସ୍ତେ ମିଶି ମଦ ପିଇ ସାରିବା ପରେ ନିଶାରେ ପବନ ତଳେ ପଡିଥିବା ଜରିରେ ଶୋଇ ପଡିଲା ଭଳି ରହିଲା। ଯୋଜନା ମୁତାବକ ମୁଁ ପ୍ରଥମେ ମୋ ପାଖରେ ଥିବା ଏକ ସ୍ପ୍ରିଙ୍ଗ ଚକୁରେ ରୋହନ ପ୍ରଧାନ ଓର ପବନକୁ ଜୀବନରେ ମାରିଦେବା ଉଦ୍ଦେଶ୍ୟରେ ତା ଛାତିରେ ଭୁଷି ଦେଲି ଓ ତାପରେ ଏକ ବାଡିରେ ତାର
ଆଡମିସିବଲ ନୁହେଁ ଏଟା ପଢିଲେ କଣ these are not admissible। ସେ ଯୋଉ ରିକଭରିଟା ହେଇଛି ସେ ନାଇଁ
that spring man
ସେଇ ପର୍ସନ ଏଇଟା ତ ଆଡମିସିବଲ ଇଟ କ୍ୟାନଟ ବି ୟୁଜ୍ଡ ଏଗେନ୍ଷ୍ଟ ହିମ୍। ଆଉ କଣ ଅଛି
ଖବର ପାଇଲେ ପବନ ମୋ ମୋବାଇଲ ଗାଡି ବାଲା ଆପଣ ମାନେ ମୋ ସହିତ ଗଲେ ମୁଁ ଛୁରୀ ଓ ବାଡିକୁ ସେଟା ଦେଖେଇଦେବି। that leading to discovery।
ତାପରେ ଛୁରୀ ଆଉ ବାଡିରେ ହିଁ ତାର ମୃତ୍ୟୁ ଜାଣ ଆଉ
then my lord one Anjali Oram her statement my lord ଯେ ରିଡିଂ ପର୍ସନ ମାଇଲ ସେତେବେଳେ ତାଙ୍କର ମା ଫୋନ ଟା ଉଠେଇ ତମେ କିଏ ବୋଲି ପଚାରିଲେ। ମୁଁ ପପନ ସଙ୍ଗେ କଥା ହେବି ବୋଲି କହିଲି। ପପନ ମା କାଏଲ ଠାରୁ ପପନ ଘରକୁ ନୁହେଁ ଫେରେ ବୋଲି କହିଲେ। ମତେ ତୁମେ କିଏ ବୋଲି ପଚାରିଲେ। ମୁଁ ପପନ ସାଙ୍ଗ ବୋଲି କହିଲି। ତାର ମା ମତେ ପପନ ସଙ୍ଗେ କଥା ହୋଇଛ ବୋଲି ପଚାରିଲା ବେଳେ ମୁଁ କାଲି ରାତି ଠାରୁ ତାର ସଙ୍ଗେ କଥା ହେଇନି ବୋଲି କହିଲି। ତାଙ୍କ ସଙ୍ଗେ କହିଲି ଯେ ଗଲା କାଲି ରାତି 9ଟାରେ ପପନ ସଙ୍ଗେ ମୋବାଇଲରେ କଥା ହୋଇଥିଲା ବେଳେ ଆଉ ସେ ତାର ସାଙ୍ଗମାନଙ୍କ ସାଙ୍ଗେ ମଦ ପିଇବା ଲାଗି ଯାଉଛି ବୋଲି କହିଥିଲା। ମାନେ she was present with that friends he told in the phone mail। that are the evidence।
ଏଇ ଦିଟା
My lord, from the entire deposition, from the entire the statements, there is a cordial relationship. There is no prior the enmity. There is no fighting or nothing else in this depositions, and no one stated that what is the reason why he killed him. And ame kehi dekhi na ho kiye tako mar dechi. This person is arrested on 8. The date of occurrence is on 5 after 3 days, and the leading to discovery is after 3 days. One from one house, dilapidated house of one person. That is, my lord. So, and my lord, the cause of death is also asphyxia. which is also.
Asphyxia can be caused by various reasons.
Mine.
Various reasons.
I also go through that. So,
And what is aspiration? When blood flows into the lungs because of some rupture caused by knife, blood can also flow into the.
Right.
It is known as venous congestion. ये जगह पूरा बंद ही जीवो.
Right.
So, and it will lead to asphyxia.
And the mother being the complainant in this case, she has stated nothing against this present petition.
कौन? Mother. Informant.
काली राति 8:30 बेलू मो घरू फेरी देखे तो मो पुओ रोहन घरे नाई मु तार आखपाख एरिया रे खोजा खोजी कली मात्र ताको पाइल नाई राति रे आसी जो भाली मु भाबी मु मो रोसी करी खाई पी सोई पड़ली आज सकाळ प्राय 5टा बेलू मोर पुओ मोबाइल नंबर रु मु फोन कली मात्र से फोन उठेला नाई दिन 10टा बेलू मोर पुओ बदले आउ जने लोक फोन उठेला से लोकटी फोन टा पाइथिबार कहि मोर पुओर फोन टिकु नेकी आसिली दिन प्राय 1टा बेलू गोटे झियो मोर पुओर पुराना फोन व्यवहार करतुवा नंबर रु मोर पुअन मोबाइल को फोन करी पपन कथा पचारला से झियो जे अंजलि ओराम जा
पपन हला जे डिसीज्ड
जोटा पढ़िली से जो फोन ने कथा हितला संध्या बेले से झियो पुणी सेही नंबर फोन कर कहला जे गतकाली राति रे से पपन संगरे कथा होइतिला ओ पपन तांको पड़ारे थिबा गांगू ओराम रो परित्यक्त असना जागा रे थिबा छाउनी तळे मद पीबा को सांग मानक संगरे जाउथबा कथा कहतिला माला दैट वाज आल्सो स्टेटेड बाय दैट अंजलि ओराम on the phone that when he contacted he told that I was with the friend mine किछि समय संध्या परे प्राय 6टा बेलू को खबर पाइल जे बरई पाइलु मखनपड़ा जिबा रास्ता रे गोटे किराना दुकान पछपाख करथिबा परित्यक्त असना जागा रे एक पिलार मृतदेह पड़िछि मु संगे संगे सेही जागा जाई देखिली सतु सत एक रक्त जोड़बुर अवस्था पड़ी रहिछि ओ तार मुह पाखरे गोटे जरी अखा घोड़ा होइछि
No, as Mr. Rai has rightly pointed out, nobody has said anything about the motive. Number one. Number two, last in theory to Honi. Only 27 is there.
Only 27 is there, and my lord, in the phone he has contacted that I was present with the friends, my lord.
Other friends, that is not specifically stated who are those friends.
Sangaman sang thila, Modabilu sang. Ki thile Sangaman seta koile.
That is not stated.
Two general letter.
My lord. And it's going to let them maybe examine, my lord, that 3 persons informant and that
informant. Even if she verbatim says whatever she has said in 161, it will not implicate the petitioner.
Specifically, there is
जो कथा पढ़ले से तेरे भी किछि नहीं.
नहीं से केवल सांग only that leading.
Since when are you in custody?
I don't 9/4/2021.
The petitioner is in custody since 9/4/2021 in connection with such and such case. The prosecution case is that that some unknown culprits committed the murder of the son of the informant by assaulting him with a sharp cutting knife, sharp spearing knife and a wooden stick. Stop. The complicity of the petitioner came to light during investigation through his disclosure statement recorded under section 27 of the Indian Evidence Act. Stop. Except for such statement, there is no other. There is no other evidence showing his involvement in the alleged occurrence. Stop. Prosecution has relied upon the statement of the informant and one Anjali Oram.
And also Raja Das.
Perusal of their statements reveals that they have not stated anything remotely to implicate the petitioner. So, the only thing that has come up in the investigation is that the petitioner was present with his friends, all of whom consumed alcohol before the occurrence. But then the names of such friends have not been stated by any person. One of the co-accused persons, namely Kunnu Bagho, has been directed to be released on bail as per order passed by this court. In BLAPL number 6935 of 2023. Stop. Taking into consideration the above fact, as also the period of detention and custody, I am inclined to allow the prayer for bail. Let the petitioner be released. Each day appearance in the court.
I do not say.
May please lost my lord. On behalf of Duxman, so my lord. The lawsuit director interim bill, my lord, ordered it 420.
File surrender certificate.
Well, in the meantime, he is released after 1 month, my lord. 1 month, my lord, February.
Miscellaneous. He was released on
4/1. 4/1/24, my lord.
4/1/24 he was released.
No, my lord. He had order dated 4/1/24, my lord. He released after 1 month, my lord. 2 days. February release.
4/1/2024 तो order ही नहीं.
4/1/24, my lord.
4/1/24 है, my lord.
4/1/24 order sheet का देखिए. इधर कहीं tag है नहीं.
Last order.
It may not have been scanned. Yes. Petitioner being a native of Bihar, 3 months. 2nd April इतना.
My
क्या वैसे release है?
February 1 month after 1 month.
The petitioner was granted bail, granted interim bail for 3 months by order dated 4/1/2024. Stop. It is submitted that she was actually released on 4/2.
My lord.
On 4/2/2023.
February, my lord, exact date is.
She was released in the month of February. As such, the 3-month period has not elapsed. This is matter after 15th May.
Item number 7.
My plea. Documents around 419, 420, 465, 467, 468, 471, 472, and 120B. The petitioner is not named in the FIR on the basis of the statement of co-accused person. He has been custody since 13/10/2023. One of the co-accused has been released on bail by virtue of minor.
I have that order. No, you don't have to. But because constraint, no, that's what the month has been released on it. Yes. So what is your rule? That's what the month he was released because he was present when the co-accused was withdrawing the money from the bank.
Yes. The main accused is Amardeep Padi, Amarjit Padi.
What is the role of this petitioner?
He identified himself as one of the officer of Orissa JE office, my lord. He was present when the meeting was conducted, and from him 1,40,000 cash was seized from the present petitioner. That is they have opened a fake ID in the name of that medical college. All are involved in this case.
The petitioner is in custody since
13/10/2023.
13/10/2023 in connection with such and such case. The prosecution case is that that medical seat though? Medical seat. That on the pretext of arranging a medical seat for the daughter of the informant,
At Bhimaboy Medical College.
Medical seat for the daughter of the informant in BBMCH Balangir. The FIR named persons, namely
Amarjit Padi.
that one Amarjit Padi and Vikas Kumar Swain took huge amount of money from him. But neither any seat was arranged nor the money was returned. Stop. In the process, about 9 lakh rupees appears to have been taken from the informant. Stop. Insofar as the petitioner is concerned, comma, he is said to have impersonated as an officer of the JEE, OJEE, and was present at the time of meeting of the co-accused persons with the informant. In course of investigation, a sum of rupees
1,40,000.
1,40,000 has been recovered from him. It is seen that one of the co-accused persons, namely Dasodab Mahanti, has been released on bail. He was directed to deposit 1 lakh. You will also same. The petitioner stands more or less on the same footing. Further, he has been in custody for nearly
6 months.
for nearly 6 months. Taking into consideration all the above facts, I am inclined to allow the prayer for bail. Let the petitioner be released on bail, subject to deposit of rupees 1 lakh towards cash security, which shall be without prejudice to the rival claims and on such terms and conditions as the court in session over the matter may deem fit and proper to impose, including the condition that he shall personally appear.
Item number 8.
Mr. Milan Kananga, senior advocate, will contest case, but will just pass over
Pass over.
after launching.
Pass over.
Item 9.
After.
This is a basic case of admitted case of prosecution. The two persons known as Debasis Behr and Prabir Kumar Singh, both are exclusive possession of brown sugar. This is admitted case of the person, all the statements. Here, my stand is, I was the driver of the vehicle and I am in custody since 2020, June 2020, more than 3 years, 9 months. Out of 18 charge sheeted witnesses, 5 witnesses have been examined. My lord knows, I know your lord's mind, because since quantity of brown sugar is heavy, even though there is no material against the present petitioner, may pray, twice he has been granted an interim bail, he has surrendered voluntarily. Only a pray 1 month may be granted because Eve is there.
File an IE.
The disposal of the same, my lord, granting 1 month.
4 kgs.
Well,
4 kgs brown sugar.
My lord, lordship kindly see page 56. My lord has discussed everything. The lordship kindly see 56, page 56.
Due to slow progress in trial, lordship granted.
Yes. Since he has not misutilized the liberty and Eid is there, only my prayer is for a grant.
Twice grant each.
Interim bail.
Twice grant each. आओ देखिए जाओ अभी आज ही कहीं की इच्छा होने तो
All right.
This matter will be commencing contract.
Lordship attention, my lord, one thing, my lord, page 43, my lord, kindly. Page 43. My lord, 10th light from the top, my lord, 10th light. My lord, write his letter number so and so. RTO Baleswar furnished the required information with the signature and seal. RTO Mayurbhanj with letter number so and so dated at the intimated the ownership details of the seized Bolero vehicle bearing registration number. In response to his office letter number so and so, it is longer than the registration number that vehicle which was seized, my lord. It is alerted to a Bajaj two-wheeler motorcycle. Stands in the name of some another person. But he has annexed the document in which it was shows that he is the owner of that Bolero vehicle. Yes. But actually the number was motorcycle, my
What to the RC book? RC book.
You give no driving license and
DL and
that registration number, that 11 same number, my. But from inquiry it is found that this number was related to the motorcycle.
Anyway, I'm not granting bail today.
There is Mahindra Bolero, page 47, Mahindra Bolero.
Page 47 বন্ধ বলে
the week commencing second week. সেটা
সেইটা যেটা আছে page 43 সেইটা কোন লেখা কনস্ট্রাক্টিভ
all right this is matter in the week commencing 6th May.
Item number 10. Made pleasure.
Malad, there is, in the last occasion, if Lordship remembers, it's a dispute between her, complainant is the wife. Against
He's
the
asking for a passover.
Lordship, may I say?
No, what do you want an adjournment?
No, there is another connected matter where the daughter, the same complainant who has also complained identically against the father-in-law. Both the matters were there in the last occasion in the same list.
The other matter has not come today.
Not come.
We'll take it up next week then along with the other matter. List this matter next week along with
ABLA PLA number.
ABLA number
13307 of 23.
13307
07
of
23. Interim order.
What is this matter?
Malad, here, Malad, there is a money suit pending. There's a divorce proceeding pending. The complainant wife says that I have wrongfully prayed before the EDCO to change the name in the property, which is for the business purpose.
Interim order to continue.
I'm obliged. Next.
Item number 11.
Alright, 302 case, my lord. Today I just received the CD. Let it be taken up as passover, my lord. Otherwise, take up.
Passover. Passover.
Passover on Friday.
Last day of the week. Last day of the week.
Maybe taken up on Friday.
On Friday.
Friday.
Passover.
Obliged.
Item number 12.
Yes, item 12.
Malad, the petitioner is in custody since 22/11/2019, my lords. More than 4 years in custody, my lords. In the earlier bail application, my lord had granted interim bail for 4 months and 6 months to conclude the trial, my lords. Thereafter, the learned court below again prayed for extension of time, and by order dated 21/11/23, my lord granted further time to dispose of the case. 3 months time was granted. First quarter of 2024, my lords. But till date, not a single witness has been examined since 11/8/2022, my lords. And the meanwhile, depositors have become hostile, my lords. And the informant, my lords, has not produced a single document regarding the transaction, my lords. I am submitting the deposition of the informant, my lords.
PW?
PW4, my lords.
You have actually enclosed some copies.
Yes, my lord. I'm giving certified copy.
All these copies you have given?
Yes,
they are on record?
Yes, ma'am.
Then I think, Mr. Patra, you have in record. You must be aware of. This also copy of deposition to reach in Annexure 2.
Let us short copy.
What to solve? You have a copy?
No,
You don't have the bail application?
State copy can't make it.
State copy nahi ki Annexure 2 achi na. Look at Annexure 2, the depositions are there. How many witnesses have been examined so far? The informant, yes, the depositor.
Yes, ma'am. PW7 till PW7.
Page number 18, I am the complainant in this kind of accused to honeycomb holding. Lekhaji directly called I came to Barampur where the accused Amir Party told me about various schemes of the deposits and asked me to deposit in the company.
Cross-examination, I have not filed any scrap of paper or document to show that I have deposited any amount. Again, my lord said I have not filed any document to show that 100 depositors have deposited 95 lakhs.
You have not filed any documents.
And regarding other depositors, here's the copy, man. Other depositors, my lords. They're saying that we have given money to the informant. What he have done, we don't know.
He has turned hostile.
Yes, ma'am. Thereafter, another 2 witnesses there.
He is also hostile.
Ma'am.
Hostile.
Ma'am.
How many investors are there? What is the total number of witnesses? How many witnesses?
79.
79.
Yes. 17.
79 ତ?
Yes. 17. 17.
70. 17 ହେଇଗଲାଣି almost 7. 10 more witnesses remain. Is what you said. Some of the depositors are not supporting.
Informant is supporting Millard, another Millard. Lordship direct with the stipulated period Millard. The rest of witness will be again.
No, why?
Because Millard, informant in his deposition clearly implicated that by being induced by the present person MD of the company Millard, he has deposited and Millard and others also deposited Millard. So Millard, some other witnesses Millard who have deposited. Let me verify.
Let me make it very clear. I'm not going to grant him regular bail. At best, I may grant him interim bail considering his long period of detention. Because trial is progressing quite slowly and it is very natural that in OPID cases trial will be slow. A huge number of documents are there. So all these documents have to be marked and all that. So I may consider his prayer for interim bail.
Only my objection is recorded.
The petitioner is in custody since
22/11/2019.
21st November probably. 21st November 2019 in connection with such and such case. Earlier, taking note of the delay in conclusion of the trial, the petitioner was granted interim bail for a period of 2 months. As per order passed in BLAP, as per order passed by this court in BLAPL number 7872 of 2022. Stop. He said to have surrendered in time without misusing his liberty. It is submitted that in the meantime, trial has progressed somewhat, but only 7 witnesses have been examined. Stop. Some of the so-called depositors who have been examined have turned hostile. 10 more witnesses remain to be examined. It is submitted that the petitioner is required to attend to certain domestic issues at home. So as such, he should at least be released on interim bail. Sri Patra, Learned Counsel appearing for the state in OPID matters, has opposed the prayer for bail, including interim bail. He submits, the informant being examined as PW4 has implicated the petitioner directly. Stop. Considering the submissions as above and the materials on the court, while not being inclined to grant the regular bail to the petitioner, I feel inclined to dispose of the bail application, directing the court below to release the petitioner on interim bail for a period of 1 month. Ashok.
On behalf of.
Mr. Jana?
Yes.
All right.
My lord, your lordship was pleased to have this matter in the instance of the other court persons.
Yes.
Bail application is also connected, my lord, in this file. And he has already released on bail, standing on the similar footing. And here, my lord, this present petitioner was arrested subsequently. And he is in custody since 12/1/2024. Here, that offences are triable by magistrate, that one.
They have cheated the tribal portion.
18 lakhs.
18 lakhs. And those persons who lordship granted bail, they are in custody for more than 6 months. Now the present petitioner, they are arrested on 12/1 and 14/1. 3 months.
Same. 12/1 ଗୋଟେ ଦିନ କଷ୍ଟଡି ରହିଲେ ଆଉ କଣ? All right, same order. What's order, huh?
Item number 14.
Section 452, 354 and 302, my lord.
307.
302, my lord.
So it is converted. Turn to 302.
My lord.
Yes, ma'am.
There is 55% born injury and dying declaration was there. So lordship call for a case diary. Earlier it was rejected.
Earlier rejected.
Yes, by me. PL number 3182 of 22.
By your lordship.
So what is the change?
Out of 40 witnesses, my lord, 18 have been examined. And nobody has implicated him.
All have turned hostile. You have the depositions.
Yes, madam.
You haven't filed them, Mr. Dasmapatra?
No, I have not filed.
Why don't you file them? And we'll call for the case diary also.
Yes, madam.
Because this is, I now remember this case. Mr. Chand was arguing in the earlier occasion.
Yes, madam.
From my order itself, I can imagine what had happened. The person was set fire.
Yes, madam.
Anyway, but we'll go by the evidence. You filed the depositions?
Yes,
You have all the copies?
I got 16, deposition of 16 witnesses.
How many witnesses have been examined?
18.
Out of?
40.
Out of 40?
Yes.
Have all the material witnesses been examined?
Yes, madam.
All material witnesses?
Almost.
Are there any eyewitnesses in this?
No eyewitness.
So for that, we will need the case diary. Let the case diary come, and you, in the meantime, you also file them.
Yes.
Up-to-date case diary be obtained. Learned counsel for the petitioner undertakes to file the copies of the depositions of the witnesses examined in the ongoing trial.
Yes.
List this matter on 29th?
Yes, ma'am.
In the week commencing 29th April.
All right.
The petitioner may be directed to solve that deposition.
Yes, madam. I will.
Further, copies of depositions we also served on the State Council.
Yes.
Item 15.
May I please?
Sir, you are waiting for which case?
Item 1 was passed over, madam.
Item 1 karo?
Right.
Wait, it is all over. There is also.
My custody since 15/2/2024. The present petitioner is the father of the accused person who is under Annexed 3. Under Annexed 3, my lord. The bail application is the co-accused person. He is the father of the
Pilochon Khosla is the main accused.
My lord.
He has been granted bail. Yes, Mr. Mishra.
Annexed 3.
My lord. And the allegation that he has present petitioner has abetted his son.
All right. The same order for this. It's a kitchen, right? Same order. Pilochon Khosla. Item 1.
Item number 1. Yes, my lord, your lordship had the occasion to hear the matter in respect of the co-accused and has granted a bail to 2 co-accused persons, my lord. And one of the co-accused persons bail order I have passed on that demand. Can we see? Transferable machines, my lord. Reach in the bail again. Lenin Chaudhary, Vidyadhara Behera.
Lenin Chaudhary rejection बाबूजी
नहीं भी देचंदी पर विद्याधर बेहरा थी लेनिन चौधरी देचंदी का
विद्याधर बेहरा
Secretary Lordship में has found that तांके account रो कहते पैसा जाई चली
flow of money has been sought to be depicted in a tabular form in paragraph 6. The figure 7 lakhs was allegedly remitted to the accounts of the petitioner and his relations, which reflect fraud.
Do you look upon kindly see Srinath Rana's 4 accounts have been seized. And your lordship kindly see the nothing has been.
No. You are
Srinath Rana. Your lordship kindly see.
How do you compare with this Vidyadhar Behera?
Same putting my lord, the same allegations, my lord, in the name of supplying transplanter machine, my lord. I have not supplied. I have taken the amount from the farmers, my lord, that subsidy amount I have taken, my lord. Your lordship, has directed the state council in the other case, how much amount has been transferred to the account of that Vidyadhar, my lord. And after that, considering that, your lordship has granted bail.
No, I will.
But this
What about the Lenin Chaudhry's order?
Lenin Chaudhry's order, my lord. That is also the lordship has granted. They have given the blame to me. Srinath I, the man I put, and so therefore your lordship has granted him. And I am
the proprietor of Tarani Auto Agency.
Yes, my lord. I am in custody since, my lord, 1912-21 for a longer period.
No, I would like to know what is the financial.
He is not only the proprietor. He is the proprietor of that agency. Along with that, he is the regional director for the Odisha. He appointed some dealers.
Yes.
So in his connivance, the password and password is with the present petitioner. If any engine number, chassis number, it was uploaded in the website. After it was confirmed by the present petitioner, then my lord, subsidy will come from the government. My lord.
No, I understand. I understand the matter. I remember. Now, this Lenin Chaudhry has been granted bail on the condition of depositing 10 lakhs. This Vidyadhar Behera, 2.75 lakhs.
And my
How much is the implication is that?
financial implication is that. Therefore, I have passed on your lordship the financial fee charge, all the charge sheet, my lord, all the accounts of mine has been freezed, and your lordship may kindly see the amount available in my bank balance.
No, he has withdrawn already. My lord, only 4 accounts, 5 accounts.
Yes.
73 rupees, 72 rupees, 3056 rupees. That was only kept in the balance maintained by the present petitioner.
So not a case how deposit thila mo nahi.
Then my enter implication, that financial implication is total that 2,45,63,000. It was some amount was credited to the petitioner account directly, and some was given by the beneficiary in cash mode. In cash mode, my lord, 74,12,950 rupees was given. And total my lord credited amount is 1,29,14,000.
What about the bank transaction? Cash to bank
transaction, it will be minus that amount. That is 55 lakhs, 1,900.
So let us accept it as 55 lakhs.
55 lakhs.
There is directly proof of that amount being transferred to the petitioner's account.
Sir, his wife, his children.
So what about Lenin Chaudhry? Lenin Chaudhry,
that instruction kete tama ta thila se
now 2 persons have been granted bail, more or less on the same footing. His implication may be a little bit more.
Yes.
But so for that, higher cash security can be imposed. Higher cash security can be imposed.
Now the amount, looking to the amount transferred to my account, my lord, because in the other case, the other case, my lord, your lordship directed this financial implication, what is the amount transferred to their account. Here is a case, my lord, I have passed on the document, the charge sheet, which has been investigated by the IO, to the copy of the charge sheet, my lord, nothing.
You just go through, you have the charge sheet?
Yes, yes, my lord.
Madam, can you see that portion, madam? Charge sheet.
You are the proprietor of Tarani agency.
Yes.
So you have 1, 2, 3, 4, 5 accounts.
Yes. In other case, in the charge sheet, I will other account kila, cash cut on the
account of this phone, you
have 5 accounts. Yes. From this, in these 5 accounts, 55 lakhs was transmitted.
No. Your lordship, they can't say that. Your lordship, can you see? They kill it.
Balance, madam. You can't see that. Such amount was transferred, madam.
I may be willing to consider your application favorably, but provided what will be the amount of cash security? That has to be seen.
Cash so see account so free jegala.
Lenin Chaudhry also that ଦେଇଛନ୍ତି.
ନହେଲେ 21 ମସିହାରୁ କଣ ଜେଲ ଥାନ୍ତା ଆଜ୍ଞା 21 ମସିହାରୁ ଜେଲ ଅଛି
ମାନେ ଏଣ୍ଟାର ଟେବୁଲ ଆଇ ହାଭ
400 କୋଟିରେ କେତେ ଦିନ ଆଜ୍ଞା ଜେଲ 5 ବର୍ଷ ଜେଲ ହବ ତାର ରହିଲେ 21 ମସିହାରୁ 3 ବର୍ଷ ରହିଲେ
consider କରିବାକୁ ପଡିବ. That has to be seen also. Nearly 3 years in custody. Yes. It has been submitted. Yes. It's a matter of trial. We don't know whether these things will be able to be proved.
Yes, my lord.
So how long can we keep him in custody? But to maintain a balance and to secure that amount, some amount can be directed to be paid towards cash security. That you have to pay. Cash security will keep you.
I'll try my right. I'll ask my client.
हाँ let it be passed over ताले
No, your lordship may impose.
नहीं कहीं impose कहीं करेंगे अब हम कोई जोड़ा कहीं करेंगे ना तो कहीं impose कहीं करेंगे
Your lordship may impose cash security not be paid, sir.
सेंड कहीं का you take
5 lakhs, madam.
आज ही नहीं की अरे लेनिन चौधरी और सोलह
10 lakhs. अच्छा 10 lakhs हो तो देखिए जे 10 lakhs हो से 10 lakhs
आरो हायर अमाउंट
हायर amount चले आ पाखा थिले सिना देई तो ये तो जेल 3 वर्ष लगे हमर सब अकाउंट फ्रीज ହେଇଛି. It's not a case matter. I have kept the money. I will just deposit it to come back.
63 rupees account रे रखिसंती तीनटा account
ना आपण आउ अकाउंट रो चाहनांती आपनकर आई योर हैंड्स आर वेरी लॉन्ग. आपण कोन रखिसोटी आसंतु.
but details I have calculated that
no I've seen you see 27 lakhs 2,488 was transmitted to Lenin Chaudhary's account.
Yes.
Considering that, I directed that he should pay 10 lakhs.
What is the amount transmitted to my account? My lord,
55 lakhs.
10 lakhs.
55 lakhs.
Kain ko kich dei par
statement my lord, the detailed statement is there my lord.
No, what is the bank statement?
That is bank statement I have given my lord. Entire bank
bank account mo jota dise kichi nahi.
fees ହେଲା ପରେ ଦେଇଛନ୍ତି
तो देखो इधर तक शांत
detailed transaction
Support
नहीं सीधी तोड़े पेंसिल लिखा है सीधा रखी दो पेंसिल रखी दो
ଏତିକି କ୍ୟାସ୍
yes sir
କ୍ୟାସ୍ ଏମାଉଣ୍ଟ ଟୋଟାଲ ହଉଛି ଏତିକି 1 crore 929 ଏଇଠି ମାଇନସ୍ କରିଦେଇଛି 1 crore 29 ମାନେ ସେଇଠି
ଏଟା କୋ account transfer
କୋଉ account ହେଇଛି ତାର ଦେଖିନି ଏଉଠୁ ଆରମ୍ଭ ବେନିଫିସିଆରୀ ପାଖରେ ଏଉଠୁ ଆରମ୍ଭ ଶ୍ରୀନାଥ ଟଣାର ତା ୱାଇଫ୍ ରିଲେଟିଭ ସବୁ ଅଛି
beneficiary
ଏଇଠି ଶ୍ରୀନାଥ ଟଣା ଏଇଠି ରିଲେଟିଭ
yes ina from କେତେ ହଉଛି
ଶ୍ରୀନାଥ ଟଣାରେ ଏତିକି ରିଲେଟିଭଙ୍କର ଏଥିରେ ୱାଇଫ୍ ଆଉ ଚିଲଡ୍ରେନଙ୍କ ଆକାଉଣ୍ଟ ବି ଯାଇଛି ପଇସା
ସିନାଥ କେତେ ହଉଛି
ଏଟା ସେଗ୍ରିଗେଟ୍ କେମିତି କରିବା ଟୋଟାଲ ହଉଛି 55 lakhs
ସବୁଲା କାମରେ ସବୁଲା କାମ କିଲେ ସିନାଥ ଆଜ୍ଞା କେତେ ହଉଛି କୁହନ୍ତୁ ମୁଁ
सर करो तो काली की तो
wife और children
sir will pass it over will take it up tomorrow
my lord
we'll take it up tomorrow then you also take Mr. Naik, you do one thing, you sit with the state council and try to find out what is the exact financial liability of your client. All right. So there will be a liability there, don't worry. Don't worry.
23 ମାସ ରହିଲାନି ସଫିସିଏଣ୍ଟଲି ପନିଶ୍ଡ ଆଉ କେତେ ପୁରା ଦଣ୍ଡ ହେଲେ 5 ବର୍ଷ ହବ ସଂବିଧାନ ଲାଗେ କେତେ ବର୍ଷ 5 ବର୍ଷ 3 ବର୍ଷ ରହିଲା Supreme Court lawyer senior lawyer from the Supreme Court passing comment that president is engaged.
Sir, the court will not pass any order in this regard. Yes, item
16
में Lords of Offense under section 376D, 376(2)(n).
First or second?
First or
then
same order में
no same order item anticipated bail की
yes
होला same order ये bail भीतर anticipated bail कितनी मजर पहुंची थी
शेष होगा
तो हल्का कर रखो ना bail उड़ा बोलते anticipated bail मॉडर्न पास करा हुआ है वो इन थी अच्छा ठीक है
item number 18
same order हाँ second order जाके इसको छोड़ो
Item 18, beg a pardon. We have the mistake. That is, his name is N.A.G. Nogendra. We have Nogendra. No, R होगा G जगह R लिखे हुए. And after filing, we made effort before filing and SR could not be rectified. So, Aadhaar card and
नवेंद्र परिडा तो ठीक है
no, his name is actually Narendra.
Narendra, acha. So this is a 2024 matter. You cannot correct the bail application in court. You'll have to do it in the before the office. I'll pass that out.
My lord, before filing in the filing section at SR and ADR level, I have tried a lot.
You tried, but you could not succeed. Now you will succeed. Now you will succeed on the strength of the order of this court.
Beg your pardon.
Learned counsel for the petitioner is permitted to correct the name of the petitioner appearing in the cause title. Stop. Yes. What is this matter?
379-34.
No, let's same order.
Letter it's done.
Letter it's told, same order.
Case of 19.
My pleasure, Lordship. My lord, in this case, 307 of IPC, the other offences are there, my lord. The petitioner name is not in the FIR, my lord. Last.
Same order, same order.
Oh, pleasure.
I don't know, 20.
May I please? The present petition stands on the same footing as your lordship dispose of the matter in respect of the co-accused. Okay. It's case, my lord.
The petition is the owner of one such truck, and you are also the owner of this truck.
No,
No, I am not.
my lord, he is not coming on the similar footing.
So owner of that.
What is the allegation? What is the?
I will kindly see the FIR, my lord.
Yes.
He is the principal accused, my lord. What he has done. On page 11, my lord, kindly see the FIR.
I will that.
Cheating and fraud in delivery for vehicles to What is your name?
Dilip Kumar.
Dilip Kumar, my lord. The confessor of co-accused, that is Amresh Kumar Swain.
Along with one Dilip Kumar Nahako. Nahak will likha hai.
Nine.
The plant is complete of the co-loaded vehicle after starting from mine, never reached the Jesuit and arrival of the Dilip Kumar Nahak enters the plant as a helper in some truck with documents of the truck which has been sold outside. He makes entry in SAP system as vehicles physically are not known.
I have for theft of that coal, he has given some money to the Amresh and Rakesh. For that reason, your lordship granted bail to Amresh. But he is the principal accused.
Reports for that.
They have done wrong entry for of the following coal vehicles without the vehicles coming into the plant. Hold it. Let him surrender. The petitioner is apprehending arrest in connection with such and such case. It is alleged that the petitioner is the mastermind of manipulation of the computer system and wrong entry for vehicles which are not physically present. Stop. As such, coal-loaded vehicles from the mines never really reached their destination and were diverted outside for sale. The co-accused person, Sujit Sahu, being the owner of one of such trucks utilized in the transaction, has been granted liberty to surrender before the court below, and with further direction to be released on bail. Stop. It is submitted that investigation into the case has progressed substantially. Taking into consideration the above facts, while not being inclined to grant anticipatory bail to the petitioner, surrender, release of bail.
Item 21.
E54-506, 326 along with other offences. There is a dispute between two brothers, allegation against the petitioner who is
Ranjit Kumar Rai.
He is one of the brother, my lord. And so far as the petitioner, he is the villager, my lord. Subject to verification of injury, your lordship.
What injury?
326 is there. There is no injury. There is allegation against him, my lord. So far the petitioner is concerned, my lord, after 14 days FIR has been lodged by the informant is the injured. The lordship directed surrender Hon'Ble subject to verification of injury, my lord.
Specific allegation is.
No, injury report the lordship may call for, my lord. Injury report ଟା ଆସୁ 14 ଦିନ ପରେ ଆଜ୍ଞା FIR ଟା ଦେଇଛନ୍ତି allegation is that ସେଟା ହବନି 1%.
Appropriate case date along with the injury report be obtained for the result of the court. List this matter on week commencing 22nd.
Interim notice.
You can IA file କରୁଛନ୍ତି?
ନାଇଁ ନାଇଁ ଏଇଥିରେ ତ ଦଉଛନ୍ତି ନା ଇନ୍ସପେକ୍ଟରରେ interim ଟା
ମୋର ମନେ ନାହିଁ ମୁଁ ଆଣ୍ଟିସିପେଟ କେତେବେଳେ ଶୁଣୁଥିଲି ମୋର ମନେ ନାହିଁ.
No
course
course
of action shall be taken with the petitioner till then.
objection.
Item number 22.
Because your lordship my
No interlocutory application is required to be filed because the statute itself provides. Yes, yes, Mr.
My name doesn't appear in the FIR. That's why lordship, though the allegation is that the Bapi Vera, whom your lordship has been pleased to consider his bail application, and 5-6 others.
No evidence is established till date.
Bapi Vera and 6
going on.
persons.
Then I'll record this submission. He says that there is no evidence against you.
Yes, on
So your apprehension is groundless.
yes.
I'll say that.
Your lordship, your lordship pass that order. Page 7, my lord, may look at. Bapi Vera and 6 persons. A 6 Bapi Vera, the lordship had considered the bail, which is there.
No, I have.
No, I am not that, my lord. Out of those 6 persons, 4 have already been arrested and they have been released by bail by the trial.
But if the state council says,
I don't.
so naturally, why should you be worried?
I don't.
The petitioner is apprehending arrest in connection with such and such case. Then state council submits some instructions that investigation so far has not revealed any evidence whatsoever of the petitioner's involvement in the alleged occurrence. As such, his apprehension of being arrested in connection with this case is not justified. Having regard to the submissions as above, the anticipatory bail application is disposed of.
Item 23.
Offense under 379, 34, 411 and section 12 of Odisha Minerals Prevention of Theft Smuggling Act. Allegation is that
Sand.
sand.
Yes.
Same order.
Yes.
Item 24.
May I please, my lord, on behalf of Mr. S.K. Divid, 24 is J.K. Ponda. Kindly tomorrow.
That's all.
Hopeless, my lord.
25.
My lord, 307 along with other allied offense. Co-accused has been granted bail by my lord, Annexure 2. So far as injury is concerned, leg rotator fracture irreparably, this is the allegation. I have annexed the injury report also.
Co-accused has been granted subject to verification of injury. Thereafter, modification has been sought for
Fracture injury.
Vital part again.
The petitioner is apprehending arrest in connection with such and such case. It is alleged that the petitioners assaulted the brother of the informant by means of weapons causing injury. Stop. The injury report of the injured shows that he sustained a bruise and a fracture injury on his fracture of his tibia bone. Though it is stated to be grievous, yet the same is not on the vital part of the body. Taking into consideration the above fact, as also the fact that the co-accused has already been released on bail, surrender release on
Item 26.
Not kindly taken up tomorrow along with bill appeal number 2208 of 2024.
weekly list is simple.
In this case, your lordship, total 4 cases are there against the petitioner.
So we will do one thing. We will call it next week along with all those cases.
My lord, already your lordship granted bail in 2 cases on 2/4 your lordship, and 2 weeks time may be given, and that will expire on 15. Therefore, I am saying your lordship.
No. Here,
your lordship bail appeal number 1972 of 2024, your lordship. And your lordship already granted bail in 25557 of 2024,
2599 of 2024 and 2/4/2024. Last week, your lordship, and 2 weeks time has been given, your lordship. And the time will expire on
No,
50.
2 weeks time has been granted to those petitioners.
My lord, in those,
So how are you?
my lord, if, in all the 4 cases, petitioner is same.
Your Lordship granted bail, page number 22, to Bharat Lal Raut and another. Similar to this
So you
petition.
do one thing. সেটাকে supplementary list খালি নিয়ে আসো। সেটাকে supplementary list নিয়ে আসো। বুঝলে? এটা খালি pass over করতে pass over করতে সেটা what is that matter?
A bail appeal number 2208 of 2024.
সেটা supplementary নিয়ে আসো। Because this is in the weekly list. It cannot change. My lord, please.
27.
May I please, Lordship? But similarly situated co-accused persons have already been released on bail in a bill appeal number 1202 of 24, my lords.
All right. Same order.
Yes, ma'am. Item number 28.
Lords, this is a offense under Copyright Acts, my lords. 4 co-accused have already been released by your lordship, my lords. 4 co-accused have been released.
All right. Wait. I have that one. Same order.
Yes, my lord. Same order.
Same order.
Item 29.
May I please, my lord? My lord, earlier the anticipatory bail application of the petitioner was withdrawn, my lord, on ABNPL number 284 of 24 by dated 18/1/24. My lord, petitioner again approached this honorable court on the ground charge change of circumstances that during course of investigation, offense under section 307, 147 and 149 of IPC was added. My lord, no injury, assault by means of fist blow and kick blow. My lord, allegation is that when the informant and his wife returning from BBSR to Paradip by car, their car was hit with one cow. As a result of the airbag of the car was blown. So when he get down from the car, some 30 to 40 local persons gathered there and started abusing the informant and his wife with allegation of drunken driving. This is the only allegation. But in the meantime, some of the co-accused persons have been released on bail by North Court below. Your lordship.
Is what is it? Let parity be maintained.
Parity.
Let him surrender. But allegation of only that face blow and kick blow.
The earlier application of the petitioner was permitted to be withdrawn. The present application has been filed on the changed circumstances of addition of certain other offences, including the offense under section 307 of IPC. It is stated that it is alleged that when a car coming from Paradip side hit a cow, 30 to 40 local persons, suspecting the driver of having of being intoxicated, started assaulting him and his wife. No weapons are said to have been used. The assault stopped. The assault was by means of fist blows and kick blows. The co-accused person has been directed to be released. Co-accused persons have been released on bail by the court below. Yes, as submitted by learned counsel to the petitioners. The petitioner stands on the same footing. Surrender release on bail.
But item 31 was also same.
31 same. Yes.
Item 30, matter relating to Swami Lakshmananda, in this granted anticipatory bail at another co-accused persons, a bail bill number 11,949 by order dated 22/11/23. And the
Same order,
yes,
not anticipatory bail. First anticipatory.
yes, sir.
Same order.
Same. Objection.
Item 32.
Lord, this case is punishable under sections 498, 304B, 302, 34 IPC and Dowry Prohibition Act. 1961-4, subsequently charge sheeted. Offense under section 498, 304B, 304C.
Other in-laws that bail application rejected, yes.
And in the meantime, the in-laws are released on bail before the session court, my lord.
Sessions court.
Yes, my
No. They were arrested.
No. One man accused Binijana, Nananda. She was arrested and then she and he.
What about Dhaneshwar Jana? What about Dhaneshwar Jana and others?
Miller?
What about Dhaneshwar Jana?
Dhaneshwar Jana, the father of the this Satsura.
What happened?
Satsura. Semane charge sheet to kati agent. Semane no, they are not.
Bini Jana?
Bini Jana jail thile, but on release he bail.
Was she party in the previous
in-law?
Her bail application has been
was she a party in ABLAPL number 8744 of 2023?
No, Miller. The available 84 of the Sasura, Vera, Dhaneshwar Jana with the
Dhaneshwar Jana and others se ki achhan?
Dhaneshwar Jana and two brother-in-law.
Two brothers-in-law.
Yes.
So what about those two? They have been their names have been deleted in the charge sheet.
Yes, Miller.
You are the husband now.
Yes, Miller.
Case diary, my lord. Up-to-date case diary you obtained. Is this matter in the comments?
Hanging matter and suicide. The petitioner is not involved because he is out of station and at the time of occurrence.
So you want the court to grant you bail straight away without seeing the charge sheet and all, without seeing the materials available in the case diary.
Man accused
304B.
Man accused Binijana is arrested.
So what is your submission, sir?
Kindly allow to anticipate.
So I will not call for the case diary. I will say straight away allow it. 304B matter. Up-to-date case diary you obtained.
Interim protection.
No interim protection. List this matter in the week commencing 29th April. Yes.
Objection.
33.
My lord, application for antecedent bail offence is 395. In respect of the co-accused person, disposal has been made on first or second or basis, same day and parity.
Because they were he was implicated on the statement of the co-accused.
Yes.
That is why
yes.
that bail order.
Yes.
What about you?
Same thing.
Same
thing.
Absconding, my lord. This present petition was absconded. And almost same manner.
All right, same order.
All right.
Item 34, urgent bail application.
30.
Item 35.
Yes.
3. He's been in custody from 24/8/2022, and the other co-accused, I think, from the same around the same time, a little later, maybe
1/10/22.
1/10/22. Facts are like this: both are builders, both are directors of a company called Orissa Homes.
Both means both petitioners.
Both the petitioners. Matter law is no more eccentric as far as the law is concerned, that OPID Act doesn't apply to builders. A discharge petition was allowed here and by Justice Sangam Sahu, that went to Supreme Court, the SLP was dismissed. Be as it may, very sadly, two other judgments, one other judgment was there quashing the proceedings. And one other came where I was arguing, my lord. They held that no, it's bad law. Although the first judgment of the went to the Supreme Court and the Supreme Court dismissed the SLP. In the meantime, my lord, all the matters that are there, they went to Supreme Court. I was also appearing a few of them, my lord. All of them stay has been granted. Stay of the impugned order that has been passed saying that the OPID Act applies. Basically, my lord, my limit of my submission is like this, my lord. A, encarcation now, my lord, for a year now. B, he has completed 31 projects without any demur. There were 2 applications have been filed for intervention. Even before I go into them, my lord, and their affidavits, my lord, Supreme Court has deprecated that very recently, my lord, that you cannot, these people cannot be heard at that given point of time for the purposes of, they can only, whatever the prosecutor says is the ultimate. They filed 2 applications. Be as it may, my lord. What application have they filed, my lord? This person goes to RERA.
This person?
This person goes to RERA, the complainant. RERA is a complete court, my lord. They also have the teeth of initiating proceedings under criminal law. They go and get a decree. They file an execution. After that, they file this application, a complaint, and a puny sum. 85% of the project has been completed. In this case, he's been languishing in jail from 2008.
So what is the basic
basic allegation is that I took the money and not given them the.
You are the builder.
I'm the builder.
You took money from this Ranjan Kumar Mahapatra.
Yes.
And you didn't.
I couldn't complete in the right time, my lord, and therefore, because of COVID, my lord, the COVID time came in, my lord. Obviously, everything went haywire. But be as it may, my lord, he's now got a decree from the RERA, and he's executing that. And here he has filed a complaint after that. And my lord, OPID Act on the bare reading of section.
Where is that order of the RERA?
Yes, my lord.
RERA.
It has been annexed. That has been annexed.
We have annexed it, my lord. My lord. Fortunately, here is the RERA order, but I'm passing on. Annexure, my lord, is.
Sir, you are Saroj Kumar Panda.
This is the execution.
Sir, you are Saroj Kumar Panda.
No, my lord, I am Manoj Panda. I think the other directors are here. My lord, the informant filed execution, my lord, is 83. It's at Annexure 5. The RERA order.
No, Annexure 5 is an estimate.
Yes.
Project expenditure incurred for the construction.
No, my lord. It's an execution, my lord. Sorry, Annexure 9, my lord. I prepare.
Annexure 9.
Page 5, my lord.
So there is no Annexure 9.
Oh, additional application.
Yes.
Annexure 9.
So there you are not a party in the RERA proceeding. Your brother was a party, but you are not.
Company was
a party.
Company was a party.
I'm the managing director.
Company was represented by Mr. Saroj Panda.
Yes, but I'm the managing director.
All right. So
I'm arrested as the director of as the managing director of the Odisha Homes.
Yes.
Annexure 10 also the order of the RERA.
RERA also Annexure 10 order is there, my lord. An execution also has been filed. I'm not on that, my lord. Number one, my lord, they are not depositors. They are people who have given money, my lord, for the entire
specific project.
Yes. And they have moneyed people. Otherwise, where were they buying 2 crores, 3 crores worth of assets? And here I am, my lord, languishing here.
Can we just go to the FIR?
Yes, my lord.
FIR will throw light on the basic nature of the allegation.
Yes. I'll trace it. That's it, page 14 onwards, I think.
Yes. 16.
Yes, 16 it begins.
So the written of
yes. I, Sri Ranjan Kumar Mahapatra, son of late so-and-so, I had booked a flat. Very clear, my lord. An apartment in Gajapati Homes near so-and-so, SOS village in so-and-so, the builder Odisha Homes in Private Limited, whose chairman Manoj Panda. Well, I am Manoj Panda. And in the office so-and-so, that there were 42 flats against the said apartment as per the agreement to hand over within 30 months from which was carried out from January 2016.
So he had booked one out of these 42 days. Then
he says that the project was approved by PTA, the same was, loan was sanctioned to individual, the agreement for selling the flat was made on so and so date, and that that on so and so date to purchase the third floor of Gajapati Homes, the term 32 of the agreement speaks of the agreement dated so and so. After the agreement, there is a tripartite agreement itself with mother of so and so of Orissa Homes, and after this agreement, I applied to the SBI for a loan. I got a loan of rupees so and so against the home loan dated so and so. In disbursement till date, the EMI has been deposited by me as per the, and the company named the Orissa Homes Commercial Direction and Aurobindo as per agreement to sell. So clearly a breach of agreement, my lord, at the most. And my lord, the series of judgments now, my lord, the Supreme Court, they deprecated and quash every matter that goes to Supreme Court as way these matters, my lord.
So this is as per the agreement for sale of the flat, period of 30 months for
Yes.
the flat has already passed.
I failed, realize the complete court, my lord. They can go, I can be compelled to pay. That's what has happened. I've been directed. And my lord, what happens is, my lord, they give some money. They're supposed to be meeting the money in a staggered payment, my lord. They don't pay the next amount. So obviously everything goes haywire. And that I cannot be blamed for, my lord. So and thereafter they come suddenly and say that give me the money. My lord, so I have myself bought a property in Delhi, my lord. I gave money and I was in a monumental mess, my lord. After I have paid almost 70%, now it is in, they filed insolvency and I'm sitting. So they have to do that, my lord. I cannot go and file a criminal case against him, my lord. Then, my lord, so the state, the country will be filled with these FIRs, my lord. It is only in Orissa, my lord, I can say with confidence, only in Orissa that these matters are coming, my lord. In fact, Supreme Court in a matter, an argument was made that it is unfortunate that the builders are being targeted under OPID when OPID per se doesn't apply. And otherwise, my lord, it's a case of 420 at the best. And it has a contract, whether it will be or not is another aspect.
What is the status of that flat?
Flat, my lord, is 85% is completed.
We have filed the photocopy.
We have filed photos also, my lord, of the.
You have?
Yes, my lord.
That is
okay.
Unfortunately, my briefing counsel, my lord, is very apt at not being quick.
No, but I can find out very quickly in this system. I can have to, it's just a click of the button.
Unfortunately, my lord, he should have.
Anyway, I have seen the photographs.
Yes,
I have already seen the photographs.
Yes. It's very
so now let us hear the other side for a moment.
Yes, yes, my lord, most certainly.
Yes.
Mr. My lord, your lordship has seen the FIR.
How does it come under the OPID Act?
I am just exactly explaining your lordship, my lord. Kindly see the FIR, my lord. My lord, the agreement was entered into on 22nd January 16 in respect of flat number 31. Your lordship, come to page number 17, paragraph 3, my lord.
Page 17.
My lord, senior has annexed the FIR, my lord.
Yes.
Page 17, paragraph 3.
Flat number 24.
Flat number 31.
Flat number 31 put name. Page 17 do.
Sir, page 17 arambaji during this time. Am I clear?
Just.
Page 17.
During this time, yes.
No. My lord, my lordship, the PNB, fifth line, my lord. The PNB had agreed for OTS. My lord, they have taken loan from Oriental Bank of Commerce, defaulted, PNB took over, OTS proposal was approved at 4 crore 6 lakhs 30,000. They have been directed to pay installment, my lord. Lordship got in first paragraph, my lord.
So that is between the builder and the bank.
Builder and the bank. Builder took 3 crores loan.
That is from the bank.
My lord, for completion of 42 flats, my lord, defaulted. And there was an OTS proposal which was accepted by the bank on an upfront amount of certain things, my lord. Further, I came to know that the shared project is not approved by RERA. Forget your lordship. Third paragraph. Also, it has come to my knowledge recently that before my sale agreement on 22/1/16 in favor of flat number 31,
got it.
Yes.
This company and its director have already signed a MOU dated 15/4/13 with Mr. Tilapati and have taken an amount of rupees 45 lakhs to sell the same plat during plat number 31. That the company and its director have prepared forged and fabricated document to cheat me. The said company and its director have also cheated several other persons of an amount of more than rupees 20 crores by cheating forged and fabricated documents. Some of the instances, plot number 24, Mahendra Kumar Ponda and Nalin Kumar Sahu, plot number 71, Dr. Sashikanta Mishra, Minati Sahu, plot number 72, Dr. Sohan Kumar Ratho and Manasi Patra. Here, in the FIR, the informant has given that these are the instances how, for in respect of the same flats, Millard, the builder has entered into agreement with two different people, including the informant, and has cheated Millard. The matter did not rest there, Millard. The builder went to the extent of Millard. Thereafter, your Lordship may kindly see. After the amount they have collected, they have to deposit with the bank, Millard, to keep the property released, Millard. The property was seized and taken over, declared as non-performance assets on 31st January 2016, and tripartite agreement was made on 6 February 2016. So when the bank was in domain over the property, and they have entered into agreement with another Tilapati to sell this particular flat, they have entered into agreement with me. So now my senior has placed that it is a civil dispute. Prima facie, if there is a civil dispute, yes, criminal case will not fly. But your Lordship says, see, this act has been enacted with a purpose. That suppose cheating Millard, he will be remained in jail. But the person who has been deprived of the money, how he will get back this money? That is why the legislation has thought it prudent to introduce this act, Millard, so that suppose by cheating some people, I have become rich, Millard. So ultimately, I will go to jail for imprisoned under section 420 or other related offences, Millard. The money will not be returned to the investor, Millard. That is the intent of the OPID Act, Millard. Here, the instances is clear, Millard. He has intentionally duped public, allowed them to invest with an promise for a return, Millard. That he has never given, and he is not capable.
It not be covered under that real estate authority.
That is for some explanation I am furnishing for your Lordships, because he is a builder. He is a builder, Millard. RERA is for civil offences, Millard. Suppose for instances, there are certain offences which is both criminal as well as civil nature, Millard. Suppose I give a slap to my lawyer friend, I may be penally liable. The state will be the prosecutor, will be penalized. But the pain he has suffered, the loss, bodily pain and monetary suffering, can it be mitigated in a criminal case, Millard? The answer is no. He can independently sue for realization of the damages which he has suffered in course of my criminal act, Millard. That is how this enactment has been made for both. Your Lordship will see section 6 is criminal in nature. Lordship will kindly see section 6.
Yes.
Notwithstanding anything contained in section 3, where any financial establishment defaults the return of the deposit or defaults the payment of the interest on the deposit or fails to return in any kind or fails to render service for which the deposit have been made, every person responsible for the management of the affairs of the financial establishment shall be punished with imprisonment for a term which may extend to 10 years and with fine which may extend to 10 lakhs rupees, and such financial establishment is also liable for a fine which may extend to 1 crore rupees. This is penal. This has nothing to do with the investor, Miller. So let's kindly see section 3 read with section 9. Section 3, Miller.
Attachment.
Attachment. That is interim attachment by the state, Miller. Subject to filing of application under section 4 by the competent authority before the OPID court, and section 9 is the procedure for making the attachment absolute. Once the attachment is made absolute, he will be, or any other person having interest in the land which has been attached, or the property which is remained under attachment by the order of the government under section 3, is subject to judicial scrutiny under section 9, Miller. There, the OPID court under section 9(5) and section 9(6), after making inquiry, it found that this property has been acquired out of the cheated amount or the default amount, Miller, then say that attachment would be made final, and the amount fixed either by putting the property in public auction and realizing the amount, it can be distributed among the depositor, so that the depositors who have made deposit, they can be returned with their investment. Miller, that is the intent of the act, Miller. Now, here it is apparent, Miller, in the Lawrence Senior has placed the FIR. The FIR itself shows an existence of a criminal offence, Miller, which is squarely covered under section 6 of the OPID Act, Miller. The trial is on. At the same time, an interim attachment was made by the government, Miller. There, the bank may have a claim, Miller, because they have, under the Surface Act, has taken over. At the same time, the person who has invested money for purchase of the flat, or those who have taken possession, they may also impede them, because the section 9 says any person having interest may not be the owner of the property. Any person having interest, your lordship knows the interest. It does not mean the right, does not mean the title, may not mean the exclusive possession. That any person having interest will have a full-fledged trial there under the civil procedure code, and can defend that either this property may be released or may not be released. And the court, in its wisdom, after trial, will pass a judgment which is final unless it is varied by this honorable court under section 38. So my submission, prima facie, he being a director, is liable, Miller, under the Companies Act also. 2013, Miller, the Company Act has got a major amendment, because every director is personally liable also. And he being there is no dispute that he is a director. He was in the helm of affairs. He entered into an agreement with the informant and others, Miller, taken money. Money has not been invested in the amount, Miller, 20 crores of rupees. Rather, by taking loan from the bank, investment has been made, tripartite agreement has been made with the bank. The developer defaults to pay the bank dues, and the persons have been paying EMIs, still have not taken possession of the respective land, because a particular flat has been sold to more than 2 or 3 persons also. So this process we have
basically amount to a case of cheating. Whether OPID Act applies or not, well, this court will not be, cannot be finding here. But just for the sake of seeing whether a prima facie case exists or not, I was asking that question. In any case, whatever you say, now what is the reason to detain him in custody?
There are two things. As your lordship knows, bail is a matter of right, jail is the exception. I don't say that putting a particular person behind the bar, the investor will get the money. But the reason behind, my lord, that there are certain things, the charge sheet has to be filed taking into account the accounts maintained by them, taken by them in a computer and putting it in a hard disk, my lord. So if these person will be allowed to roam free, my lord, they will take away the primary evidence out of their own computer. They will thread the
This FIR was lodged way back in August 2022.
Yes.
So investigation may have progressed substantially.
Investigation has not been completed. Charge sheet has been filed, keeping the investigation open.
So, but why did you not seize those computers?
Miller, they are like the catch, Miller. Miller, these are the moneyed men, Miller. Your Lordship may kindly visualize, these are not ordinary criminal acts, Miller. Your Lordship knows. And plane goes missing, Miller. For the last 3 years, it is 370 odd people who are on board. The entire world is now on
Malaysian Airlines.
Yeah.
No, not 3 years. How do you have to?
Kuala Lumpur. These
MS 307 or something like that.
it is a apart from other here. The entire world is unable to test them out. And now your Lordship may visualize the investigator part, Miller. These people, they have kept their own information in different area, Miller. We are working on it. We are still unable to find it out. We have filed the charge sheet keeping the investigation open. We are still working on it. Where that 20 crores are, when
was the charge sheet submitted?
Your Lordship, ma'am, charge sheet has been submitted on. And 27 And
what further investigation has unearthed so far?
That your Lordship may kindly see in the charge sheet, your Lordship will find we have named there are investor list as well as the witnesses list we have given Miller. The investor list up to date Miller 46. Initially we found 42 class, 42 investor. Now after these keeping the investigation open, we have on 16/11/23. That is after filing of charge sheet. It has come to our notice that 4 more persons have invested and now the investigation comes to 17 crores 59,75,062 rupees. We are still working to get other 2.5 crores of rupees and it has not been found out. So
what is your response to the submission that 85% of the apartment is complete? And they've enclosed some photographs. That will show the house also.
If your Lordship see the instruction, my instruction is there. That the bank has taken over the entire position under the Surface Act, Miller. And even if he is allowed by your Lordship, Miller, he may not be in a position to complete it, Miller. Because the property, the Surface Act is a central statute, Miller. And unless they got a relief from the DRT, Miller, they cannot even work on it, Miller. Because now the bank has the domain over the property, Miller. They are no more they are never the owner, Miller. They entered into agreement with the owner for construction. And the construction as well as the land has been taken over by the bank. So in no case, they can complete the construction. And so far the photograph is concerned, I have never seen. I do not know whether the photograph is that of my lord.
I also don't know, my lord, how we can say with so much of impunity that I am supposed to be a thief, then I am going to run away. That they are going to complete it. My learned friend's client is going to complete my building, is it, my lord? This is no way to submit, my lord. I am still, not, my lord, sentenced to prison, my lord. I am supposed to be deemed to be clean. Why should they make such allegations, my lord? It's very unfortunate, my lord. Being hyper is all right, my lord. But there's a limit to it, my lord.
Your Lordship may kindly see the RERA order, my lord. But I have submitted. It is based upon the records my lord senior has placed, my lord. Your Lordship may kindly see RERA order, page 17, paragraph 2 of the direction, my lord.
Yes.
The respondent number 5 may continue the case.
You are reading from.
I am reading from complaint case number 221 of 2022.
Is it a Kuti annexer?
My lord senior has given it.
Acha. Page 72. आरंभ होइछे. Page 72 आरंभ होइछ तो
Again, ସେଇ document ର 17 page ସେ order ଦେଖୁ ସେଇ page ରେ ଅଛି Sujata Tripathi.
Annexure 6 is starts from page 72, ends at page 76.
No.
My
I'm explaining that with a clearance from the RERA. No, I am explaining, Miller. There are two Miller under, as I have said, Miller. RERA is for civil wrong. Section 80 says, for the civil wrong, even a criminal act can be independently under the RERA Act, Miller. That is for civil wrong, Miller. Here is a criminal wrong. It is independent because of section 88. So it can run concurrently. It is not dependable upon the action of the RERA, what my Lord Senior has placed me. It is independent. And it can be run concurrently, my Lord. And therefore, bereft of the fact that RERA, whether saddle him with the responsibility of paying something or not, it is independent. Section 9 and section 6 is independent because of the provision of the section 88 of the RERA Act. Therefore, my submission, this OPID Act has got no nexus with the RERA because of section 88. So it can be run independent. And there is no quarrel over the or the dispute that he is not the director, he is not responsible, it is not his case that he has no taken the money, he has been falsely implicated. So therefore, my submission, as your Lordship has seen in other case I have given, these are economic offenders. They have to be treated with more rigors than the ordinary criminals. Ordinary criminals do a wrong to a particular individual. They are doing a wrong to the society. Now, your Lordship may kindly visualize whose presence is more difficult to the society, whether a single individual criminal or a person who is committing wrong to the entire society and bearing the contrary right. That your Lordship has to take into consideration while considering the application of my Lord Senior. Or
nothing else, until is very, very clear.
We are appearing
For 6.5 crores, for 60,000 crores, a man is granted bail. Not as
You are?
I am for the informant.
the informant thing, my lord may allow hearing, but I must give this judgment to my lord to see. My lord, it's a case where anticipatory bail was moved and there was a concession made. I'm not supposed to give you judgment. Concession was made that on the basis of that, my lord, a deposit was to be made. My lord, he couldn't pay the money, he stayed in jail. They went to Supreme Court. Supreme Court said, and there, my lord, one of the complainant was filed, and then from the rooftop he began shouting that let him deposit, let him do it. He said you cannot be heard at that stage. For a bail application or anticipatory bail application cannot be even heard. And they refuse the intervention. Only for the purpose of
saying
this.
that the informant has a right to assist the honorable court to come to a just.
I will hear you. No. That's why my lord, I hear him. I have no problem. My lord, I'm only saying that law has developed this way.
Yes.
From the very beginning, I will bring on the record that the petitioners are not the original owners of these property, for which they have conspired and I have been defrauded not only to the petitioner but also to a large number of people in the society. From the very beginning, I respectfully submit that on the date of the entering into an agreement.
Look, let me tell you something. This is not a PIL. In an FIR, you have come up with a specific complaint of being cheated, of being duped, or being falsely lured by the petitioner to deposit in that project. Now you have got an order in your favor from the RERA, taking care of the money that you have deposited.
But they are not also cooperating in the proceedings before the RERA, my lord.
You cannot argue as if you are the prosecution.
No, my lord.
Because Prosecution will only say why their presence in jail, their captivity is necessary. You may only say how you were victimized. This court therefore poses it to you, since you have already got an order from the RERA, what further benefit would it accrue?
With humility, and what the petitioner is trying to submit before this honorable court is that the criminal intention of the petitioner is telltale evident on record from the very initiation of the agreement, my lord.
So it amounts to cheating.
My lord. So
It's a case of cheating. That's
so far the proceeding before the RERA is concerned, my lord. Despite a clear-cut direction from the RERA, had it been the clear intention of the petitioners to justify the illegality, they could have paid the amount, my lord. That was not done by the petitioners, despite the order of the RERA, my lord. There is also an execution proceeding, and they are also not cooperating in the lower forum, my lord. So I have been deliberately cheated time and again, not only before the agreement entered into in the closed doors of the promoters and the builders, rather before the judicial authorities, my lord, because the courts below, my lord. And what happens, my lord? After entering into an agreement, I had to take a loan from the bank. I had to suffer financially a lot, my lord. And I was paying the EMIs regularly. But having come to know that I have been defrauded and the property does not belong to the petitioners, my lord, I cannot express my difficulties that I have been suffering immensely, my lord. Furthermore, what have the petitioners done, my lord? They have forged the signatures of the mother of the petitioner. So
that's all right. That's all right. Let us accept whatever you say to be correct. Without going entering into any further. Whatever you say is accepted as correct by the court. Now, does it justify their continued detention? Because it would amount to retrial conviction. You are not in that.
So I bow down to the good conscience of your lordships.
We can't do that.
My lord. So what I am
So the court will always look at Article 21.
Correct, my lord. I respectfully bow down.
I make it very clear.
Correct, my lord.
It's not that I'm allowing this application now. I'm not allowing it now.
With
respect, the court will always balance your arguments against Article 21.
My lord. So had it, for that reason, my lordship, the petitioner respectfully submitted before this honorable court that had it been the good intention of the petitioners, they could have complied with the direction of the RERA, my lord.
How? Being inside the custody, how could they comply?
My lord, they have a lot of people, my lord. They have an organization, my lord. They are not individuals.
That I'll be asking at the end. I have reserved that question for Mr. Das at the last.
They have a good organization. They have.
What is your amount?
It is 40 lakh.
40 lakhs.
40 lakh.
And any other? Yes, Mr. Kaur?
I have more than 1.3. I have about 3 interveners. Each one of them I have 40 lakhs. Now I was 75 lakhs. I was 37 lakhs.
So you have heard the amount?
Yes. Actually, construction roof casting, nothing else. But
What amount can be paid?
Nothing, my lord. They cannot even pay a copper. Because, my lord, 21 out of the 21 have been finished. This was the last one that I was doing. After that, he's in jail for the last 1.5 years. Now, my lord, the property which is there in that main road, my lord, which is incidentally, my lord, happens to be a family member, that is also being managed by someone else. All the people who have made the
you can take instructions from your client.
But not be, no, I have taken, my lord.
I'm saying something else.
Yes.
You can take instructions. Supposing the court grants you interim bail for a period, on the condition that you will arrange money and pay some amount to them.
We have constructed. Whatever money. My lord,
I will not pass that order today without you obtaining instruction from a client. I don't want to impose anything to you. Mr. Bhuya, I think the prosecution should have no objection to that.
Yes, our only duty to see that the money is recovered and paid to the people.
Yes, because there is an execution proceeding going on. There is an allegation that.
Yes, I quite bow down to that, my lord. I don't know what level of instructions I have.
We'll take it up again tomorrow. We can continue tomorrow.
My lord has to keep it to Friday, my lord. I'm traveling.
Yes. Friday, we can keep it to Friday.
You
because number of amount which is invested,
it's a question of securing some amount and striking a balance. That's all.
Your lordship also keeping in mind there is another EOW case against him, and there are 9 other general police cases against him.
All arising out of the same thing. My lord, what is happening? They're in jail, my lord. Not only one, all the marginal bailers are finished. And in all the cases, Supreme Court has granted bail without any, anything. Without any payment, my lord. That also was a point raised, my lord. And every one of the cases, my lord, bail has been granted. After 1 year, every one of them have been granted.
These are the list.
There are 42 crores for allotted 47.
If he sells everything that he has, my lord, he cannot pay anything. I don't think he can pay anything. Until he comes out and goes for an arrangement with the creditors or something, go to the
that is why I'm saying interim bail. I can grant you interim bail, so you can show your bona fides. In some cases also, I
don't even know how much property he has. Yes, my lord, keep it to Friday. But my lord, I have not been able to.
No, this is. I think this is this is something. This is a reasonable proposition.
Yes, my lord. I quite bow down to that, my lord.
It's very easy to either allow the bail or to reject the bail.
Yes.
But in that, what this court would like to do is to go a step forward to see that the balance is struck.
Yes, my lord. So I am only saying that, my lord, what will I put to my client?
That if he is released on interim bail, let us say for about 1 month or 2 months,
yes,
can he arrange some money to pay at least some amount, not the entire amount, but some amount?
No, I mean, my lord, I must have the figure sum. My lord, if I put to him, he will not be, I mean, he may not be, I mean, physically may not be having the money. My lord, we were doing that very matter, my lord. My lord, this is a case of Dr. DC Mishra, Dr. Devendra Mishra's property, which my brother, incidentally, his son is my brother-in-law who died. That matter, my lord, is going on, and he is not able to go give anything. Mr. Hota, who had investment there, Prasanna Hota, all others, my lord, the people who had bought the property, they have been pulling and constructing, and now it has come to some level. So this is the precarious condition where he is, my lord. He's probably stressed himself too far. 21, he is a chartered accountant who came into this, my lord. 21 projects he has completed, 31 projects he has completed, my lord. He has no dishonest intention, my lord. He put into his mouth more than he can chew. But whether that justifies, my lord, without trial for 1.5 years, 2 years, my lord, that he should be granting, maybe staying in bail.
I'll call it again on Friday.
Yes,
just for we don't. We only on the condition that we will not hear it again. I have heard sufficiently.
Yes,
I don't have to. You don't have to place the facts again. Only if this can be worked out, well and good. Otherwise, I'll close it on that.
Yes. And my lord, all the compilation of the judgments, my lord, I'll give it to my lord only for my lord.
On Friday?
I don't want my lord even to look at them. My lord, I'm only saying in all the cases that bail has been granted by the Supreme Court.
Yes.
I'll give all of them, my lord.
Yes.
I made a compilation, I can give it.
Yes.
And my learned friend is aware that all the other matters which have gone, that OPDI Act, all of them have been stayed by the Supreme Court. All of them.
So this will be.
May I just request? The last matter, item 100.
Yes.
Can it be called on Friday?
It will be called on Friday.
Yes.
Today, actually, it will not be called.
Yes.
It will be called on Friday.
I'll be requesting my lord to keep it for Friday since I'm coming back.
Please ask. You can make a mention. If it reaches, just make a mention for Passover.
Yes.
I'll remember.
Yes.
We are immensely late for lordships.
Yes.
Item 36.
My lord, being the driver, cost distance 9 20 my lord.
12
20 my lord.
Then
More
outside.
than 3 years and 6 months.
1,318 kg. List one move.
My lord, in the meantime, some of the co-accused already released on bail.
Co-accused gone. Co-accused have been released on bail.
My lord.
Any outsider?
No outsider. This is the one outsider.
List one move.
37.
I please your lordship. Lord, here the petitioner is in custody since 1st February 2021 and charge sheet has been filed under section 363, 366, 305, 376 2N and 6 of POCSO Act. And allegation is that
376 is also there.
Allegation is the dockage of 14-wheeler truck lordship. Last occasion, your lordship. 14-wheeler truck lordship.
The truck has been recovered?
Yes, truck has been recovered along with the 5 accused persons. They have been arrested. And this petitioner has 4 criminal incidents of similar nature. Similar. That is there.
Since when are you in custody?
Lordship 31/5/2023.
The petitioner is in custody since 31/5/2023. It is alleged that the petitioner and 3 other, total 4 though?
Total 4.
3 other persons. The petitioner and 3 other persons committed theft of a 14-wheeler truck after assaulting the driver and helper in the jungle. They also stole the mobile phones, ATM cards, driving license of the drivers and the papers of the truck. The truck was recovered in course of investigation and the petitioners were arrested. In the meantime, charge sheet charge sheet has been submitted. Considering the above fact as also the period of detention in custody, I am inclined to allow the proceedings. Condition the petitioner shall appear before the IAC of Kothana, Champua police station on every Sunday at 10 a.m. for a period of 3 months. But each day appearance in the court without seeking the presentation. Yes.
Item 39. My lord, here my lord, present petitioner is in custody since 15/3/2023. More than 1 year.
इसका 321 kg 490 gram.
ऐसा किसी नहीं है
किसी ने
It is only statement is the basis of implication. Only 11 antecedents and 7 similar.
So far the present case is concerned, matter has to take into account this aspect, that what is the allegation or what is the page 10 again. On sustained interrogation, thereafter the detainee Parameswar Khara disclosed that one Prasad of village such and such along with petitioner. They had been to the nearby place, they have collected all these things and Madam skip that and last 2 lines of that particular.
As per the plan, he along with driver Prasad and
D time the 200% rating, therefore everyone for topic can.
Yes, he was not present in the spot. He was arrested in one 307 case. He has surrendered and thereafter he was taken into remand in this case. And it has been established that this present petition was there, played away. And
through court statement.
yes, but similar nature antecedents are there. 7 out of 11.
All right. The petitioner is in custody since
15/7/2023.
15/7/2023 in connection with such and such case. ଦି ଜଣ ଧରା ପଡିଥିଲେ ନା?
ନାଇଁ ଗୋଟେ କାମ ହଉଛି ପରମେଶ୍ୱର ବୋଲି ଦେଖୁଛନ୍ତି ଯୋଉ ପରମେଶ୍ୱର ଖାରା।
One person, namely Parameshwar Khara,
Parmeshwar Khara
was a person, namely Parameshwar Khara, was found to be in possession of 321 kgs of contraband ganja. 322 kgs of contraband ganja. So, on interrogation, he gave out the name of the petitioner and another person as having loaded the ganja bags in the vehicle being driven by him. Stop. There is no evidence to show that the petitioner was present at the spot or of being in possession of the contraband. So, then State Council has also produced the case diary. He also fairly submits that apart from the statement of the co-accused Parameshwar Khara, there is no other independent or admissible evidence to show the involvement of the petitioner in the alleged occurrence. As such, the ratio laid down in the case of Tofan Singh versus so-and-so squarely applies to the facts of the case. In such view of the matter, I am inclined to allow the prayer for bail. Let the petitioner be released. Condition number 1, he shall appear before the IAC of Kothana, Machkund police station on every Sunday at 10 a.m. for a period of 6 months. Each day appearance in the court without seeking representation. Next, he shall not commit similar or any other offence while on bail.